Page 4, 38, item 38 for admission. That this matter, they have broadly seal cover marking.
Seal cover I have received from the University of Oxford.
देखिए कौन सा था?
Directed for press admission.
This is not description.
এটা co-heading রে পড়ে লাগে।
It is additional agency. I'm sure press admission going to.
The cover को पकड़ के वो दे दिला I am discharging the risk.
Just a minute. We are just going through. Have you got that order, 16/12/24 order? Please place it so let us see that.
Yes, I'm just.
16/12/24.
Mail. The petitioner Dr. has filed this petition.
সেইটারে ভার করনা নিচে যে এটা সেখানে বসছে।
The petitioner Dr. filed this petition with the prayer for a direction for the evaluation of the left of the answer scheme in the law property in question number 5A as per the guidelines provided under the scheme of evaluation. By detailed order dated 27/11/24, we noted down the contention raised by counsel for the petitioner that it is not a case of evaluation of answers to the question which has already been valued. Rather, it is a case where the petitioner has answered a particular question, but she has not been awarded any marks for such answer. To command the attention of this court on that day to question paper on the law of property, which is having full marks of 150, and it is mentioned that questions are of equal value, and the candidate has to answer 6 questions, selecting 2 questions from each section. There are 3 sections in the question paper. That's section A, section B, section C. From section B, the petitioner has given answer to question number 5 and 8. She has attempted questions number 8 first and answered to question number 8A, which starts at page 56 and ends at 55, and she has been awarded 5 marks for the answer. Similarly, she has answered question number 8B, which starts from pages 55 and ends at 57. And she has been awarded 4 marks for that answer. And in the end, the total marks for the answers to question 8A and 8B have been awarded 5 plus 4, that's 9, which has been mentioned in the mark sheet under Annex A. 6. So far as question number 5 is concerned, is divided into 2 parts, that is 5A and 5B. The answer to question 5A starts at page 57 and ends at page 58. It seems that no mark has been given for that answer, as it has been done to the answer to question number 8A and 8B. So far as the answer to question number 5B is concerned, that it starts from page 58 and ends at page 60. And in the end, only 4 marks has been given, and accordingly the same has been mentioned in the mark sheet under Annex 6. Counsel for the petition has placed reliance on the decision of this court in case of Pragya Lalit Mishra versus OPSC and others, disposal on front. We noted down the contention in the order dated 27/11/24 that the petitioner has answered 2 parts of the question number 5, that is 5A and 5B. But for answer to question number 5A, no individual mark has been awarded, and accordingly, We asked P.K. Mohanty and senior advocate appearing for the OPSC to obtain instruction as to whether the contention of the learned counsel for petitioner that the petitioner has not given any mark in respect of her answer to question number 5A is correct or not. If she has answered any answer, why
And
marks
if
have
she has answered.
answer.
Hmm.
Why marks have not been added in the end as has been done in respect of other answers in answer script under Annex 6. Today, counsel for the OPSC has filed counter affidavit on behalf of opposite party number 2, wherein paragraph 7 it is mentioned as follows: that the reply in aberments made in para 7 and 8 of the petition, it is humbly submitted that the petitioner has advanced his contention and alleged that in law of property paper question number 5A has not been evaluated by the examiner. In this connection, it is mentioned herein that the concerned examiner has made tick mark on the question number 5A and question number 5B. Hence, it is obvious that the examiner has read and examined the answers thoroughly and finally awarded 4 marks for question number 5, and the same mark has also been posted on the front page of the answer script. Hence, the total marks secured by the petitioner in law property paper, 53, is correct and proper. Regarding improper marks secured by the petitioner in the other questions of law property, it is humbly submitted that the marks awarded by the examiner after thorough evaluation of the answers given by the petitioner, and it is solely at his discretion. We are satisfied with the stand taken by the OPSC after carefully going through the counter affidavit and on hearing the learning counsels for the respective parties and on going through the question paper of law of property 5 questions 5, Annex 5. The answer script of the petitioner 5 Annex 6 in the interest of justice and equity. We propose the following: the opposite party number 2 OPSC shall send the question papers of law property Annex 5 and Xerox copy of the answer script of the petitioner to the Vice Chancellor of 3 universities: National Law University Cuttack, MS Law University Cuttack, and Law University Bangalore in 3 sealed covers. The Vice Chancellor himself, herself or himself, or through the concerned professor on this subject shall assess the marks to be awarded to the petitioner in respect of her answers to question number 5A and question 5B, section B given in page 57 to 60 of the petition separately, and send the copy to the OPSC in seal cover, who in turn shall produce the same before this court on the next date.
Okay. Yes, Mr. Mohanty. So you sent it to the Vice Chancellor of the university and you have received the
Yes, I.
What will
এইটা কার হলদিয়াটা বাণী বিহারে?
And where with the chick ଦେଇଥିଲେ forwarding the forwarding letter ଦେଇଥିଲେ
କାହିଁକି ନା ଏଇଟା ତ ଆପଣଙ୍କର ସ୍ପେଶାଲ ସେକ୍ରେଟାରୀ ଆଡ୍ରେସ କରିଛନ୍ତି ଆପଣଙ୍କୁ।
ହଁ ସେଇଟା ମତେ ଆଉ ଗୋଟେ ଚିଠି
ହଁ
ଖୋଲ ଖୋଲ।
ଏଇଠି ଗୋଟେ ଫରୱାର୍ଡିଂ ଲେଟର ଗୋଟେ ଅଛି ନା କାହାର ଉତ୍କଳ
ଖୋଲିଦେଲେ ଜଣା ପଡିବ।
ତା ଭିତରେ ଥିବ ସେ ଗୋଟେ ଗୋଟେ ଖୋଲ। ଅଲଗା ଅଲଗା ରଖିଥିବ ହେଲା ସେ ଯାହା ଇଏ ରିପୋର୍ଟ ତା ଭିତରେ ପଶିବ। ତା ଭିତରେ ଏଇଟା ଆପଣ କହୁଛନ୍ତି କାରଣ ଆରଟାରେ ଅଛି MS ଲ କଲେଜର ସରି ମଧୁସୂଦନ ଲ ୟୁନିଭର୍ସିଟି ତେଣୁ ଏଇଟା ହଉଛି କହୁଛନ୍ତି କ୍ୟାପିଟାଲ ଥିବ ତା ଭିତରେ। Madhi, please, that is law university. Bani Bihar. Upon the Hatter Upper Lekigan. That would be better.
Bani Bihar.
Actually, law university Bani Bihar. Actually, Bahare would get a lot money in the forwarding type. They Upper Lekigan, Etausian, Modustan lawyer. Follow. No, State House. Our law university Bani Bihar. What's the consecutive?
Bani Bihar Law University is National University and Madhusudan Law University. So far as Bani Bihar is concerned, that is Utkal University, Department of Law.
Department of
yes.
कि आधे लिखा है लॉ यूनिवर्सिटी बाणी विहार भुवनेश्वर तो मुझे ସେଇଥିପାଇଁ କହିଲି ଲେଖିବା ପାଇଁ ଚଳିବ
The questions are put to guidelines provided under the
So-
scheme of law.
No. Mr. Mahanti, if all the university have, they, in their own way, they stated that 5A, it is not marked and they have given their mark. One has given 3, one has given 6, another is given 2. So if we added it, it comes to 11, divided by 3 means it is 3.5 for that particular question, 5A.
They have stated that no marking.
For decision, Sanjay Singh versus Office on this same subject, on
No,
this.
Mr. Mahanti, let us be, ଆପଣ
ନାଇଁ,
ସବୁ ଜିନିଷ ବର୍ତ୍ତମାନ ହେଇଗଲା, ମାର୍କିଂ ଆସିଗଲା.
ସେଥିରେ ମୋର ଖାଲି ଗୋଟେ question ହଉଛି ଯେ whether they have provided the scheme of evaluation.
ଆଉ ପଛକୁ ଆଉ
ଆଉ
ଯିବା
ପଛକୁ ଆଉ
we are
ଯିବା.
not going back
We are not going back. We have adopted a method and 3 best university of our state, it has been sent and it has, the mark has been awarded by all of them and 1, 3, 6 and another is 2. So it is 11 by 3. It comes to 3.5. 3.5 it is added to 53. Then it comes to, they 53 ରଖିଥିଲା ନା?
ସେ ରଖିଛି 385
No, 53 is
paper.
One law.
So 53 means it comes to 56.5.
So two things are very clear. That one, in against 5A, there was no mark awarded, which
That is clear.
that is clear, and mark has also been awarded, independent of anything, with utmost transparency.
That's the only thing is what is the scheme of paper? Suppose somebody has given 6. What is the
No, that
in this
We are now the examiner. Now we have to see in a way,
that
because the reason
that
being,
is
in
why
absence
we
of
are- that is why, since we have made it clear that
only Supreme Court
it's
has
an
said,
exceptional case, we have done it. In spite of the decision, because we were also convinced that yes, mark has not been awarded. That is the reason why we all did all these exercises. Now the result has come. If you get 3.5, the total marks become 56.5. Whether you are to get any benefit or not, that's just true, because we have to pass this order like
Yes.
this. So whether any chance of getting any benefit? So if not, then entire exercise.
total mark, I have secured 385.
What is the qualifying mark?
Qualifying mark is 390.
390.
Then only your lordship's indulgence.
No.
Indulgence theory, why I'm pursuing a lot here in this case, just have a glance. I'm just reading out. It's a decision of the Supreme Court on this subject, where a dock of, well, just I'm placing it. When a large number of candidates appear for an examination, it is necessary to have uniformity and consistency in valuation of the answer scripts. Where number of candidates taking the examination are limited, only one examiner, preferably the paper setter himself, evaluates the answer script, it is to be assumed that there will be uniformity in the valuation. But where a large number of candidates take the examination, it will not be possible to get all the answer scripts evaluated by the same examiner. It therefore becomes necessary to distribute the answer scripts among the several examiners for valuation, with the paper setter or other senior persons acting as the head examiner. When more than one examiner evaluates the answer scripts relating to a subject, the subjectivity of the respective examiner will creep into the marks awarded by him to answer script allotted to him for valuation. Each examiner will apply his own yardstick to assess the answer script. Inevitably, therefore, even when experienced examiners receive equal batches of answer script, there is a difference in average marks and the range of marks awarded, thereby affecting the merit of individual candidates. This apart, there is hog dove effect. Some examiners are liberal in valuation and tend to award more marks. Some examiners are strict and tend to give less marks. Some may be moderate and balanced in awarding marks. Even among those who are liberal or those who are strict, there may be variance in the degree of strictness or liberality. This means that if the same answer script is given to different examiners, there is all likelihood of different marks being assigned. If a very well written answer script goes to a strict examiner and a mediocre answer script goes to a liberal examiner, the mediocre answer script may be awarded more marks than the excellent answer script. In other words, there is a reduced valuation by strict examiners and enhanced valuation by liberal examiners. This is known as examiner variability or hog-dove effect. Therefore, there is a need to evolve a procedure to ensure uniformity intercept the examiners so that the effect of examiner subjectivity or examiner variability is minimized. The procedure adopted to reduce examiner subjectivity or variability is known as moderation. The classic method of moderation is as follows. The paper setter of the subject normally acts as the head examiner for the subject. He is selected from among senior academicians, scholars, senior civil servants, judges. where the case of a large number of candidates, more than one examiner is appointed, and each of them is allotted around 300 answer scripts for valuation. To achieve uniformity in valuation, there, where more than one examiner is involved, a meeting of the head examiner with all the examiners is held soon after the examination. They discuss thoroughly the question papers, the possible answers, and the weightage to be given to the various aspects of the answers. They also carry out a sample valuation in the light of their discussion. The sample valuation of scripts by each of them is reviewed by the head examiner, and variation in assigning marks are further discussed. After such discussion, a consensus is arrived at in regard to the norms of valuation to be adopted. On that basis, the examiner are required to complete the valuation of answer scripts. But this by itself does not bring about uniformity of assessment interest the examiners. In spite of norms agreed, many examiners tend to deviate from the expected or agreed norms as their person is overtaken by their propensity for strictness or liberality or eroticism or carelessness during the course of evaluation. Therefore, certain further corrective steps become necessary. Third, after evaluation is completed by the examiner, the head examiner conducts a random sample survey of the corrected answer script to verify whether the norms involved in the meetings of examiner have actually been followed by the examiners. The process of random sampling usually consists of scrutiny of some top-level answer scripts and some answer
Just Mr. Bhanti, just show those paragraphs because we are reserving.
I'm passing on.
Please come to that page number 16, annexure 3 of your brief. So, mark secured in preliminary examination is 64.394, right? And so far as
mark secured
main written examination, এটা কোন হয়? এটা হলো
এটা পৌঁছে জেনারেল ইংলিশে পাইলা 94 তারপরে প্রসিডিউরাল ল
ସବୁଗୁଡାକ 150 full marks না কোন
150
So paragraph 5 of the repetition of the
paragraph 5
what my learned friend said, he has said that I was pointing of 5 marks.
No, just paragraph 5.
Yes, sir.
2022 she secured 94 acha.
That I have said.
84 hela, 78 hela jurisprudence, 70 hela so and so out of 100. However, she was awarded so and so, prevented of qualifying for this one. এইটা ଯୋଉ ଆପଣ ଇଏ କଲେ ଯେ 5 ମାର୍କ ହେଲେ ବୋଲି ଆପଣ କ୍ୱାଲିଫାଇ କରିଥାନ୍ତେ that is annexure P କୁ ରିଲାଏ କରୁଛନ୍ତି ଆପଣ ଯୋଉଟା ଆମ ପ୍ଲେସ୍ କୁ
And he is saying that in paragraph 8 I should have been awarded 11.
Out of 1.5.
So please pass on that. We are reserving.
What my learned friend said, so for the scheme of evolution, that is equally that has been cemented for all kinds.
This is the operating paragraph I have marked.
ये जो 23 था तो कुछ
On the self papers, that is on the subject.
अच्छा यही सब गुड़ाको ताकि received develop करी
That your lordship bring on record by recording.
Yes, yes, we will bring it.
Just as per the order dated
ଗୋଟେ additional judgment ଦେଉଛି
ଦେଇଛନ୍ତି paragraph ଟା ଖାଲି mention କରିଦିଅନ୍ତୁ tick ମାରି ଦିଅନ୍ତୁ paragraph rely କରିବାକୁ ଚାହୁଁ ସେଟାକୁ underline କରିଦିଅନ୍ତୁ then you can see ଦେଇଦେବେ hey Mr. Mahathi please use this red and give a tick mark or underline it whatever it is. In pursuance of the order dated 16/12/2024 Mr. P.K. Mahanti, land senior advocate, appearing with Mr. Pranam Mahanti for Sajid Party number 2, OPSC, has produced the mark sheets answer marks awarded
Marks are fine, the answer sheet.
marks awarded in the answer to question number 5A and 5B of section B from the Vice Chancellor of the universities, that is National Law University Cuttack, MS Law University Cuttack, Law University Bani Vihar Bhubaneswar, in 3 sealed covers. Stop. The sealed covers were opened and marked assessed by the examiner, now ordered by the examiner for in respect of the appropriate questions perused, and it is again directed to be kept in sealed cover. Mr. Srinivas Mahanti, and counsel appearing for the petitioner, the land counsel appearing for the OPSC, Mr. Mahanti, land counsel for the petitioner, placed decisions in the case of so and so, the data gets engagement. Hearing the board, judgment is resolved. Number 30. Now you call to you.
Supplementary list, item number 1.
My lord, for the petitioner, I will this petition assign the validity and illegality and property of the order. Annexure 1 passed by the opposite party number 2 in gross violation of the order passed by competitive authority under OGLS Act. My lord, last time, my lord has given time me. I have sought some time to collect the records which have been submitted
Before the ASO.
ASO. I have collected all these things.
Please file it with a memo, not in that way. Please file a memo and also give it to the.
I will file a affidavit.
That would be better.
Yes,
and also serve a copy on the London State Council, right?
Mine.
So we are recording that you are ready with the documents and you are to file with an affidavit of the petitioner, right?
Moreover, I have also collected that Trupti Mishra, my side plot, the judgment, the ASO what he has given, same order.
No, that whatever you want to file, just file with a memo, and this should be filed with the affidavit, right?
Eight-three format. What is per order, sir?
In pursuance of the order dated 19/12/2024, the Land and Council for the petitioner submitted that in pursuance of the order dated 19/12/2024, he is for the relevant documents which you have filed with the ASO in objection case number 8349 of 2012 for recording the name of the petitioner in the ROR, and he has to file those documents with an affidavit of the petitioner, giving the copy to the Land and Council for the state. So can it be done during course of this week?
Yes.
Or during course of this week? So ଗୋଟେ ସପ୍ତାହ ଆମେ ଛାଡି ଦଉଛୁ, ତା ପର ସପ୍ତାହରେ ଆସିବ. Place this matter in the week commencing from 27th of January 2024. Mr. Mahanti, the contention that was raised, we have noted down in the order dated 19/12/2024. That objection case, it has been mentioned that the petitioner has not produced the relevant papers justifying the transfer of the suit land in her favor. Now, it was his contention that not only the petitioner has got the documents, but it was also produced before the concerned authority. So we asked him that what documents you produced, just give it with him now. Now he is having those documents, and with an affidavit, he will definitely mention that these are the documents which I have produced before the ASO. So you are to take instruction.
Yes.
Whether
that document in fact
produced or not.
Yes.
Because he has not produced now. All right. So on receiving the aforesaid documents, the Land and Council for the state shall obtain instruction from the concerned authority as to whether those documents were produced for recording the name of the petitioner in the ROR or not.
My lord,
Free copy of the order.
I have collected this from ASO office.
ठीक अच्छी अपन ଦେଇଦେବେ ସେ ଦେଖେଇବେ ତାଙ୍କୁ. You have got the documentary proof that you have produced the document. That's all. Now he has to how, in spite of that, how he has written that you have not produced the document. So that is the common 27 January.
Item 2.
That 2-1 and 2-1 you can
the matter may be withdrawn only.
Memo is filed on behalf of Srini Mahapatra for withdrawal of the writ petition. Memo is taken on record. The petition is disposed of. So here.
Item 3.
That permitted over memo same one.
Item 4.
Borrower have applied a loan on the opposite party. Due to non-payment, opposite party
has sent me a letter to auction the land and negotiation is going on. Due to the absence of regional manager, he is going to join it 20th January. It has
No,
been
let him
pending.
join, but you are challenging the auction sale notice.
Sir.
Right?
Sir.
The annexure 6 series is that.
Sir.
Now your alternative remedy is available elsewhere, not before this court, in view of the decision. Yes, item 5.
Item 5, I am applicant by
Yeah, what do you want? Next week. Phone order is not. You also took adjournment on 9/1/25. Then we are giving you a long adjournment. Why it will come every week and yes, one counsel for the petitioner 6 for an adjournment. It appears that on 9/1/2025 also adjournment was sought for. This matter February was signed.
Item 6.
Next.
Let it form next week along with WPC number 115 of 415 of 2025.
These are connected matters.
Yes. Two sisters have filed.
All right. The land council for the petitioner submits that WPC number so is connected to this WPC and the matter will be listed next week along with so on. This matter. Yes.
Item 7.
Yes. This matter is relating to land acquisition matter. Annex of 2 series page 14 LLC. A notice has been issued to me for acquisition of my land, inviting any objection LLC. Then I file my objection on Annex of 3 series page 15 that is pending since LLC 13/12/2024. My respectful submission direction may can be issued for disposal of my objection LLC.
Prayer may can you class, but I have no objection. But prayer is very peculiar. Direction shall be issued in diversion of Suvarnarekha irrigation.
This is my objection.
The Mr. Jena, land counsel for the petitioner, submits that after the notice dated so under annexure 2 was published, the petitioner filed his objection on dated P12/2024. My annexure 3. But thereafter he has not received any communication from the said authority, say of the phone officer opposite party number G2, and therefore direction may be issued the to consider the objection filed by the petitioner in accordance with the land council for the state has something the same. For the date of production of the certified copy.
Lordship, shall I pray one thing, a reasonable opportunity be given to me for personal hearing, Lordship?
Opportunity of personal hearing shall be provided the petitioner. Yes.
Oblige, Lordship.
Item 8.
Item 8 may please, Your Lordship. Here, Your Lordship, the land of the petitioner has been acquired under the Coal Bearings Act. And Your Lordship will find that the petitioner had made an application, a claims case before the Learned Claims Commission, which is at Annexure 1, requesting for survey of his structure, which is his house over his land. Your Lordship, the Learned Commission has dismissed the said claims case, which Your Lordship will find page 23.
Yes.
On the ground, the only ground is that as per the satellite imagery, there was no house or structure prevalent on the land as on the cutoff date.
All right, that is the order of 2019.
2019, yes, Lordship.
Then what happened?
My lords, thereafter, my lords, pursuant to the directions of the learned Apex Court, that any grievance which is required to be filed has to be filed before this honorable court, this writ application has been filed. Now, my lords, as per the latest order, the Claims Commission is no more functional.
Right.
The judgment has come out, my lords. And which is why, my lords, I pray that notice be issued, because MCL has to answer this particular question. They have completely relied on satellite imagery.
No, that order, we are told that the order was.
My lords, I have the order. Your lordship may see. I have.
Final order has been passed.
Yes, your lordship. Final order is passed. Specific direction is that Claims Commission will not be extended.
Right. Just carry on.
Yes, ma'am. January 3rd, 25.
Just. Which are the relevant paragraph, madam?
Your lordship, the directions start from paragraph 22 onwards.
Please place it.
My lords, page 18, para 25, your lordship may see.
20.
Page 18, para 25. The
Yes.
first direction regarding the extension of the Claims Commission. Para 25, page 16.
Okay.
Page 18, sorry.
That was torn down. Okay.
That was turned down.
No, apart from that, what has been observed?
Direction.
Apart from that, your lordship, the learned Apex Court has basically rejected that basically no other actions have to be taken by the commission. And second of all, any other grievances as per the previous order of the Honorable Apex Court has to be dealt by your lordship.
No,
Like I said,
Is it,
Yes, your lordship. Your lordship may see page 13. Page
that
13.
is specific order passed in that particular case.
My lords, that is in page 13, my lords. Para 69, page 13. The judgment dated 3/11/2022, which was the main speaking order. It is lastly directed that any fresh dispute on account of calculation of compensation, disbursement of benefits would be adjudicated by. Thereafter, your lordship may find. I have also annexed the judgment after that. Page 32 of my writ application. Page 32 of my writ application of the brief finance. It is further clarified that in case of any grievance by any party with respect to any order or report of the Claims Commission, the grievance should be first articulated before the High Court in appropriate proceedings. This is the order. This is 10/10/2023.
The same has been reiterated.
The same has been upheld again.
Yes. This was already released, but what about them? Is it applicable to all? Particularly. Just to say that
Which is the village here?
My lords, this is Tumulia. This is one of the last 4 villages which were left out.
Yes.
Village Tumulia.
This is Tumulia.
Petition has been filed by the petitioner, Devar Chennai. The prayer to set aside the order dated 2/12/2019 passed by the Claims Commission in claim case number 36 of 2019 with a further direction to the Mahanadi Coalfield to make assessment and grant compensation for the structure bracket a Pokka house with cement flooring, one veranda so and so lekha is prayer question pertaining to plot number 181, khata number 144, village Tumulia. The Land Council for the petitioner drew the attention of this court the order passed by the Honorable Supreme in case of so and so annexure 3 wherein while adjudicating different applications it has been held that in case of any grievance by any party with respect to any order or report of the Claims Commission, the grievance should be first articulated before the High Court in appropriate procedure. The High Court shall decide such disputes on their merits and in accordance with law and the previous judgments and orders of the Honorable Supreme Court. The Land Council for the petitioner submitted the recent judgment pronounced by the Honorable Supreme Court on 3rd January 2025, wherein it was held that there shall be no order for extension of the term of the Claim Commission. So far as this case is concerned, since it relates to village Tumulia, after going through the earlier orders passed by the Honorable Supreme Court, and so also the observations made by the Honorable Supreme Court, paragraph number 24. Since this matter is to be adjudicated by this court, issue notice on the question of admission indicating therein
the matter shall be disposed of at the stage of admission. No notice be issued to opposite party number 4. The Land Council for the state accepts notice on behalf of opposite party number 1, 5 and 6. Extra copies of the petition be sought from Land Council for the state. So far as opposite party number, tankar ki achanti ye
Mr. Devraj Manti usually appears for Mahanadi Court.
panel achana je single council.
Panel.
Notice of requisites for issuance of notice on opposite party number 1-3 by speed post with proof of delivery shall be filed within a week. Matter will be listed 4 weeks after. Counter affidavit filed.
Item 9.
The present petitioner is a land user or displaced family person, wherein his land was acquired in the year 2002. Lordship, Annexure 7 is the representation for consideration before opposite party number 5.
You have not received any communication.
No.
After the file. All right. Annexure 7 is the representation, which is to be disposed of by so and so from date of action certified. Okay. Disposed of. Yes. Public.
Item 10.
Yes, Mr. Niyamati.
Application under section 14 of Surface Act is pending before Bernard DM Angul Melot. So in the meantime, 60 days have expired, but it's pending there.
So you obtain the status of the this writ petition has been filed by petitioner Bank of Baroda for a direction to the opposite party number 1, district magistrate cum collector wood for disposal of this case number 14 of 2024 filed under section 14 of the Surface Act within a stipulated period as mandated under the said act. The Land Council for the petitioner submitted that the application was filed on the file.
17/1/2024. Thereafter, one revised affidavit was filed on
Who's listening in the government?
date charter.
List of dates.
Well,
List of dates.
17/1/2024. But sorry, ma'am. In the meantime, what has happened? Order has been passed.
Order
has been passed. Security he has kept in evidence because an essay is pending before DR.
So then
This he cannot pass. Either merits it may be taken on record. After I will file an additional affidavit or because he has passed that order because
Yes,
essay is pending.
just
As your lordship knows,
stay order passing.
rather we have given an affidavit that no stay order. No stay order has been passed.
The section 40 is not required.
It's all right. We just want to know that factual aspect. Mr. Niyamati Land Council, however, submits that on 19/12/2024, an order has been passed by the collector on Good.
18. Order dated 18.
Order dated on 18/12/2024, an order has been passed by the opposite party number 1. Opposite party number 1. That since another case has been is pending in the court of tapes recovery relating to this matter. The section 14 application was to be kept after disposal of the said case by the presiding officer D.R.T. Patel. The order is produced and taken on record. Land counsel for the petitioner has supplied the copy of the order he wants to. Land counsel submits that he wants to file this order with an affidavit. And you have to take also some additional ground in your petition because you have to challenge it that he cannot keep it like that.
No, that is the problem with me because technically I filed it earlier. Now in the
now you can amend it there. And it's to file with an memo and also file an application for amendment of the petition in view of the order dated 18/12/2020. Right? So there is this matter and immediately after that application is filed. We are granting you 1 week time, and the moment you file an interim application, it will be listed. All right? Okay.
Item 11.
May dear notice, answer 4 is pending OP number 3, my lord.
Annexure 4 is to be disposed of by OP number
3, my lord.
Item 12.
Actually, on behalf of Nirod Kumar Sahu, I prayed 15 days. On behalf of Nirod Kumar Sahu, I prayed for 15 days more time.
Previously in this case.
Actually, in the case, I don't know about the case. He's in hospital.
Alright, the mention is made on behalf of Mr. Nirod Kumar Sahu for adjourning. Please this matter. You want 2 weeks?
Yes, sir.
Please, doctor.
And an appearance of Union of India.
Union of India की actual court में
Item 13.
Madam, 1 week after I pray, madam, I have not prepared it for personal problem.
Alright, and counsel appearing the petition. It's 1 week.
One
time of this matter.
Item 14.
14 million next week. I pray for next week.
Next week. Like the mention is made. You have got power, madam, in this
Yes,
case.
ma'am.
You are P. Bastia.
Yes, ma'am.
Bastia and council submits. Then matter is not made. All right.
My lord, I will appear in this case.
Please file. You are appearing for this private party?
Yes, sir.
They create a private party. How many parties are there? Rari, so, Madam Sir, a copy of your petition
Yes,
on that. Council and council files power for opposite party number 1. And same is taken on record. The name of the land and council be reflected in the closed list and stored. Let a copy of the petition be served by the land council for the petition on the land council for the party. During course of this week, you serve it.
Yes, ma'am.
No?
The canteen is not taken up 2 weeks after.
All right. The land council for these ones, so 6 plan adjournment, please.
Item 15.
Please, present petition is challenging in notice dated 2/24 my lord regarding lease of the shoot plot for construction of a community center my lord. Present petitioner highly objection for the Procedural not to lease of the shoot plot my lord as because the community center is situated in front of a present petitioner's house my lord. For that reason, present petitioner is unable to move from his house to outside my lord to go to the main road my lord. And it's to the pending my lord. An objection. 13 to 2024. And you have not received any communication. No. All right, annexure 2 is the objection which is pending with Tahsildar. Tahsildar कितने number party करछन्ती?
OP number 5.
Opposite party number 5 insert the display of time limit. Yes.
Item 16.
I pray for the adjournment.
1 week after. Mr. Patnaik says for an adjournment. Yes.
Item 17.
Please, madam.
The matter relating my lord non-disbursement of the
Item 16 for OP number 3 am appearing.
Which case?
Item 16 previous.
previous one.
ସେ adjournment ମାଗିଲେ ଆପଣ ନାଁ record କରିବାକୁ ଚାହୁଁଛନ୍ତି
OP number 3 पे. They are filing.
ବୁଝୁନାହାନ୍ତି 16 name of the land council be reflected in the process. Yes,
Yes, ma'am. It's a matter relating to my lord land acquisition proceeding where my late parents' land which was acquired and no award has been disbursed. For which my lord I before this writ application before this honorable court under annexure 1, this honorable court was pleased to direct the concerned secretary that Sundargarh to consider my application. The collector my lord rejected my application saying that in annexure 3 that the amount has been disbursed in favor of my late father. Then I applied in application. From there, my lord, I got referred that annexure 4 versus 3. There's 17 on 18. No disbursement has been given to my father.
Case number serial
190. 190 name is
98.
Kisan is my
198 years.
yes.
The wife of late Puladhar Kisan.
Yes, is my father. And Ukul Kisan is my mother, and it is blank. And my father died in 2015, and my mother died in 2008.
जोटा लिखा है 3,44,200 सेटा जो कौन?
These are the amounts has to be paid to my father, late father. The land
Already paid.
not paid.
Oh, not paid.
Not paid. The amount, my lord, 0.4 land, decimal of land with house.
You mean to say it would have been that signature?
Yes, signature. All the payment has been made in 2020, and it is in blank.
Sure.
But the court has that
You can be like the
para 16 page 16 the land acquisition Tahsildar Hengir has submitted a para-wise comment on dated setting which reveals that the land compensation amount in respect of the acquired land of village Bangur has already been disbursed to the father of the petitioner. But my father died in 2015.
It is a particular land.
Same particular land. Same particular land.
This writ petition has been filed by the petitioner, Dukku Kishan, with a prayer to pass the order dated 10/5/2024 of opposite party number 2, Collector Sundargarh. In holding that the compensation of the acquired land has already been provided to the father of the petitioner, Puladhar Kishan, and cannot be provided again to his legal heirs as claimed by the petitioner in his representation. The Reliance Counsel for the petitioner submitted that earlier when the petitioner approached this court in WPC number 225151 of 2023, with a prayer for a direction to the opposite party number 2, Collector Sundargarh, to sanction and release compensation of his parents in his favor. I had order dated 24/7/2023. The writ petition was disposed of with a direction to the opposite party number 2 to consider the representation filed by the petitioner and to pass necessary order in accordance with law. It is the contention of the land council for the petitioner that after the order of this court was placed before the opposite party number 2, the collector called for parawise comments from LAO, from Tahsildar Hengiri, who submitted the report in which it was mentioned that the compensation for acquired land has already been provided to the father of the petitioner. It is the contention of the land council for the petitioner that thereafter he filed an application right under the Right to Information Act and obtain information from the Public Information Officer Hengir Tahsil, and the same has been annexed to the Annexure 4, which would indicate that no such compensation has been paid as it would be evident from serial number 198, which is having the name of the mother of the petitioner, Urkuli Ishan, finds place as the displaced family, and in the extreme two right-hand columns have been left blank, where the person who has received the compensation amount is to put the signature public LTI and the name of the bank and account number, etc. are mentioned. The two columns which have been left blank, and it shows that no compensation amount has been paid by the opposite party number 2. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Land council for the state accept notice on behalf of opposite parties number 1.3. Yes. Chari by upon the notice? No. Requisites for the issuance of notice on opposite party votes shall be filed within so and so. The extra copy of the petition will serve. Matter will be placed after 4 weeks. Counter affidavit if any. Filed in the meantime. Yes.
Item 18.
Say compensation in lieu of land acquisition, Annexure 6 of the lands. Similar matter decided by the Honorable Court in WPC number 12,000 to 58,29. Annexure 6 of the lands. Annexure 6 similar matter decided by the Honorable Court in WPC number 12,000.
Annexure 6.
Yes.
They order pass over.
They order pass. Same moja, same person.
Annexure 6 contempt order decision.
Annexure 6 पर सबने comply कर लेनी, contempt को comply कर लेनी. Annexure 6 अच्छी page 23 to 26. Page 26.
Annexure ताजेरे थिला कितने number annexure का disposal?
Annexure 6 है.
Annexure 5.
5 series थिला 80 with
5 series the representation.
That is to be disposed of in accordance with 6.
All right. Yes, disposal. Next.
Item 19.
Land and houses have been acquired by the opposite party for the purpose of NTPC new asphalt. The compensations were also paid, but so far the rehabilitation and the displacement benefit petition is coming after them. Earlier the petitioner represented to the opposite party number 2, and due to inaction of the opposite party number 2, petitioner moved before the court in WPC number 10789 of 2023, which is disposed of on 24th 2023 with a direction to the opposite party to consider the petitioner's grievance within a period of 3 months.
What happened?
And thereafter, they have slept over the matter. Again, petitioner moved before this honorable court in contempt number 6480 of 2023, which was disposed of on 2/9/2023, again providing 3 months time to the number 2. Again, the petitioner moved before this honorable court in contempt number 2791 of 2024, which was dropped due to filing of a false affidavit by the opposite party number 2 that they have already complied. And petitioner kindly says the notification annexure 1.
No, he upon opposite party number 2 could you representation dispose of that has not yet been done.
They have petitioner is a permanent resident of village Mosun Heta. Lands were acquired in the village Mosun Heta. But that has been wrongly, they have listed that petitioner is a man of Bhumipur.
All right, so they have disposed of the representation, holding that you are not entitled.
No.
That is the reason. But what is the reason? Where is that?
Kindly see the notification.
Page 29 is the reason.
No, notification is there in 11 to 14.
11
Why they have turned down your prayer? What is the reason?
29.
29.
Yes.
That is the last
And yes, and the reason starts with
annexure
28.
A. Annexure A. Page 26.
Yes.
Page 26 at 29.
Yes.
The petitioner is not entitled to get any.
The petitioner Dipun Kumar
Sahu.
Now the present petitioner is Arjun Sahu.
हाँ.
Indramani Sahu. Dipun Sahu.
28 to start teaching us. May I read that?
ये पिटिशनर होची इंद्रमणि साहू आपण कहले परा या केस रे भी ऑर्डर टा पास हेची
Earlier the petition was filed by the three petitioners. Indramani Sahu. Dipun Kumar Sahu. And
ଦି ଜଣ ଫାଇଲ କରି
ଦି ଜଣ ଫାଇଲ କରି
ଦି ଜଣ ଫାଇଲ କରି
ଆଜ୍ଞା ସେ ଦି ଜଣ ପରେ ଅର୍ଡରଟା କଲେ
ଠିକ ଅଛି
the petitioner is a man of Manipur. He has no residual house over that plot and not residing at page 26 last but 5 line. The petitioner
ଆପଣ କଥା କୁଆଡେ କୋଉଠି କୁଆଡେ
28 ର first paragraph ରେ second paragraph the petitioner Indramani Sahu 28
son of Arjun Sahu resident of village Bhumipur.
पढ़ले the petitioner Indramani Sahu
son of is the resident of village Bhumipur. The petitioner has purchased the case plots in village Mosunheta and converted the said agricultural land for homestead purpose. The land of the petitioner 20 decimal in village Mosunheta has been acquired for the construction of ash pond of NTPC Konia. The petitioner has already been received due compensation from the office of the special land acquisition officer NTPC Onugul. The petitioner has constructed his temporary house after notification of 11/1 with a speculative intent to get higher compensation, rehabilitation and resettlement benefits after knowing about the acquisition of land by NTPC Konya from any sources in that village vicinity area. The cut-off date of the village is the petitioner was resided over the said plots with their family members before 11/1 notification.
read it out.
As per the provision of rehabilitation and resettlement policy 2006 under section D of section 2, it is clearly denied that a displaced family means a family residing in the project area prior to the date of publication of notification under the provision of relevant act and on account of acquisition of the homestead land is displaced from such area are required to be displaced. In this regard, the Disaster Management Department, Government of Orissa have also issued guidelines, guide letter number so and so dated 2010, stating that the persons or families who are ordinarily not residing in or near the project area not eligible for this for and shall not be enumerated as a displaced family for the purpose of rehabilitation and resettlement benefits. Persons or families who are normally residing in or near the project area for a period of at least 3 years prior to the date of Section 4(1) notification called Act 1894 above may be considered as ordinarily residing there in for purpose of R&R benefit. As per the SIA report submitted by the NCDS Bhubaneswar in the year 2018, no affected person in village Mosunihata has been identified as a displaced persons of his families. Hence, the petitioner is not eligible and entitled to get.
So how do you meet it?
May I kindly see. Mr. 1, page 11. Notification was made for the purpose of ASPON in the village Mosunihata.
Yes.
Thereafter, the occupant number 3, Special Land Acquisition Officer, prepared a list at starting from page 12. Indramani Sahu, Pita Arjun Sahu, Huipu. But number 110/25 belongs to the petitioner at page 30. Arora entry at page 30. Accordingly, they have paid compensation also to the petitioner. May I kindly see all my annexures at 5 series. Kindly see page 35. The voter identity card, which was issued by the authorities in the year 1996, 35, right hand side, bottom part, 31/1/96, that was issued to the petitioner. Thereafter, at page 36, the driving license issued in favor of the petitioner, date of issue on the top of the 17/3/1994. The residence certificate also issued by the competent authority that petitioner is a permanent resident of village of Mosunihata. In spite of all this, they are playing hide and seek role with the petitioner.
Okay, but what about this that you constructed the temporary house
No manner.
after the notification?
No manner. Notification was made in the year 2017.
And the cut-off date was 4/12/2018.
18.
You
And
constructed the temporary house thereafter.
No matter. That land has been converted to the homestead land in the year 2015. They have admitted. Can this is ROR at page 30. Bottom part. ROR दाखल case number 1027/2010 हुकुम मुताबक 110/4 ରୁ दाखल खारिज case number 64 मुताबक plot number.
That is status of the land use that. But what is the apparent proof with regard to the construction of the building?
Have you mentioned anywhere in your petition that this finding or observation which has been made that the house that was constructed after the cut-off date was totally misconceived and there was no documentary or some proof authority and they should not have made such observation, and in fact your house was constructed prior to the cut-off date? Have you taken such awareness? Then how can they have stated in a particular way why you are not entitled to get this here?
कट ऑफ डेट फिक्स अप कले अपन कंपेंसेशन पाइगले किंतु कट ऑफ डेट परे अपन घरटा तयारी करछन बोली अपन पाइबे नाही बोली ताकर केस तो अपन ताकू अपन को रीट रे गवर्नमेंट नेकिन तो डिनाय करिवार थिला ना नाही इन एडिशन टू दैट सपोर्ट कौन देई थाले हाउ वी विल नाउ
प्रथम आज्ञा से कहउछन आई एम नॉट अ मैन ऑफ मोशन हेटा आई एम मैन ऑफ
there are two grounds two grounds they have denied your claim. One is that you are a man from the other village. You are now you have, let us say, you have that ground cannot be sustained because you have got the voter identity card, other things, residential certificate. So what about that part? That construction was after the cut-off date. And you should have at least taken some grounds in your retribution. You have to then amend the petition and also file any documentary proof or anything like that so that it can be, this court can prima facie come to the this observation that the finding is not correct. And unless you take it, how can it be? The learned counsel for the petitioner seeks some time to file an interim application for amendment of the writ petition. Raise this matter after 2 weeks. Yes, next.
Item 20.
I may be submitted to place on behalf of Mr. Samal.
Your representation is 3524. तापर किसी communication पाइना the authority no. No. Annexure 3 to be disclosed to the family.
Item 21.
They are in this essay number 66 of 2023 for disposal.
And limited there is that to fix a time limit to dispose of that matter. And the
appear kaleni samane upon petitioner pai
and the auction purchaser.
Acha. So you are the opposite party. The borrower are
here you are the petitioner. I'm here the petitioner.
Right. The borrower has filed the essay.
Challenging the order order under section 14.
So whether all the parties have already entered appearance.
Appeared and filed their written statements.
Okay. So have you moved any action for early disposal of the essay before the authority?
Yes, opposite party number 56. This is the petitioner before the DRT is seeking adjournments several
order sheet file करछन्ती.
No, ma'am.
केमती आमे जानिबु ये unnecessarily case टा adjourn होछि ताकि कहिबु गोटे direction दे. So many cases are pending before the concerned authority. One maybe that 2022 हुए तो किसी केस थी आपन को होछि 2023 मसिया र केस टा तो आपन को प्रेफरेंस कोन ପାଇଁ दिए काहे किसी केस सब केस इससे फाइल करछन्ती माने सब केस गुडा को सेही टाइप रो केसिंग थिबो जोड़ा कि प्राय चैलेंज हुए माने ऑप्शन सेल नोटिस हो कि हो इस चैलेंज हुए.
So fix a time limit so that matter can be disposed of.
Why are you not producing the order sheet? You see, once we entertain this type of petition, hundreds of petition will come this court. Pass the order, pass the order. So blanket order cannot just produce the order sheet. Let us be satisfied. It may be done in one or two cases, taking into account the exigencies or anything like that. That yes, in spite of everything, the court is just passing the order of adjournment. But once we entertain that every case, if it comes, then again, सब केस रे order एंती जो तांको time limit तो 3 मास भीतर आपण disposal करंते. That does not proper.
Not agreement.
You produce the order sheet,
Well,
right? This petition has been filed by the petitioners, so and so, for a direction to the opposite party number 1 to dispose of it. Essay number so and so within a stipulated period. When counsel for the petitioner seeks for an adjournment to produce the order sheet of the said case by next date, how much time you require?
15 days.
15 days. Please this matter in the week coming from 3rd February roughly by 1 4 time. So
Item 22.
My lords, an additional affidavit was filed with the petitioner on 9th of January 2025 and to give a reply thereto. My lords, may list it on the week commencing 27.
So John Kirkland Senior Advocate submits that he has received the copy of the additional affidavit filed by the petitioner in response to the report of the DR Judicial date 9/12/2024, and he wants to file his reply.
Yes, and
within
my lords, this may be listed week commencing 27th of January.
and the matter will be listed on week commencing the week after this matter.
Yes, ma'am.
We commencing from 27 January 2025.
Item 23.
Along with contempt application.
23 month of October. For amendment to incorporate certain subsequent events.
IA number
14250.
yes.
I wanted to incorporate certain subsequent events.
Right.
By
Have
way
you
of
sought a
amendment.
copy on the
I had served it, my lord, in October 2020. No objection has been filed.
no, who is the appearing for those
My lord, I am appearing for
I,
appeal number 1, 2, and 3.
Mr. Patnaik, Ajit Patnaik.
My lord, I am in VC, my lord. Pardon me, my lord. Pardon me, I am in VC.
None of them have filed any objection.
No.
So,
No, my lord, just a minute. In the last date, my lord has ordered, directed that to take necessary steps with regard to payment of compensation. We have issued him notice to receive the compensation. They are not coming up and receiving the compensation.
But now central government that we will take necessary steps with regard to payment of compensation. If at all
We have taken step. We have intimated him to receive the compensation. They are not coming up.
you will take necessary with regard to payment of compensation. So, what is your instruction? They are entitled to get compensation.
Yeah, my lord. Yes, my lord.
So
we have intimated him several notices.
Them to receive compensation.
Yeah, my lord. They have attached the copies with their IA. They attached all the copies. We have issued notice with their IA.
This the subsequent IA which has been filed.
Yes, my lord.
My lord.
Here, my lord, I have incorporated all those documents and I seek that an amendment because this should be a subsequent event during the pendency of the writ petition. My lantern is not filed.
My lord, if they are dissatisfied with the compensation amount, they can approach the right forum. That is arbitrator.
You are to receive it if you want extra. That means
they can approach the arbitrator.
Lords will allow me a minute. What has happened? This is the acquisition of 2013. After that, your lordship knows that even
no, my lord, that was not the scooping.
That if you are changing the public purpose, then there will be. And when we claimed it, the order itself that was passed by this honorable court that either you pay the compensation or you release the land within this period. Then thereafter they suddenly issued a notice compelling me to receive the amount of compensation, which I say that this has happened during the pendency of the petition and I have taken certain grounds challenging that. So that can be disposed of on merit.
Okay.
Once the
Mr. Patnaik, you do one thing. Are you interested to file any objection to this interim?
My lord, I will file the objection.
Okay. So you file it. We'll consider whether amendment is to be allowed or not, and if thereafter we'll decide the case. And what
2 weeks maybe 2 weeks may be allowed to.
Just a minute, Mr. State Counsel. You are also a party in this writ petition, and your number is opposite party number 4. Do you want to file any objection to the interim application? To also the Union of India. Mr. Pari?
Yes, my lord.
Whether you intend to file any
objection to the interim application that was filed since long.
I didn't receive any instruction. I seek for instruction. If required, we will find.
All right, we are
This
taking
the I
2 weeks.
they didn't serve the copy of the I. Let them serve the copy.
Copy देना थी.
I have a copy पाइनो. Copy print here पाइ.
On IA copy also.
IA copy has already been served as stated by Mr. Das. So if you have not,
I can give it another copy.
if you have
I
not,
have the receipt also.
Oh my lord, I have received this writ petition and also a rejoinder affidavit. Not I.
Mr. Padi,
Whatever documents you received, we have.
and then he will serve a copy. So, look on the IA number so this is an application for amendment. Land Council for the appearing for Mr. Patnaik. You are appearing for whom? Which opposite parties?
1 and 2.
1, 2, 3, 4.
1 to 3 you have initially stated.
Opposite parties number 1, 2, 3. So also the Land Council for the state and Land Debt Channel appearing for the opposite party number 5 submits that they will obtain necessary instruction regarding filing of objection, if any, application. Place this matter on 3rd of February 2025. Yes.
Problem.
Item 24.
Mr. Samantrai, how much delay is there? Pointed out by the stamp reporter.
For the
760 notices have been issued.
Lots of direct all are central government authorities. I can give the notice.
Okay. CPL 429 of 2024. That copy has been received by you, Mr. Pari.
Yes, yes.
So
one copy of received only. Same APL copy has been received.
You are appearing for all of them.
Yes, yes. The delay, but last order I have seen that dismissed. None is appeared neither from the appellant nor from the respondent.
It is coming for the.
No, my friend is saying about the original order in the writ of it.
No, this CMAPL obviously has been filed to to restore that writ appeal, which was disposed of. So, you receive the notice on behalf of this all the opposite parties.
Yes.
And if you want, he can serve an extra copy, and then we'll hear it a week after.
I'll seek the instruction. Thereafter, also may take up for it.
All right. The submit that he will appear for all the opposite parties. Let a copy of the writ petition, extra copy, be served on so and so. Matter be placed on 3rd February 25. IA number लिख लीजिए बेटा IA order का पास करिए है ना. There is an application for condonation of delay in filing the CMAPL. The stamp reporter has filed indicated that there are 760 days delay है ना in filing the CMAPL है ना. तापर में ही matter will be put for consideration of the application, interim application for condonation of delay. Okay. Yes. Great.
Item 25.
Please, I want to withdraw the writ petition with a liberty to file better.
Mr. Pujari, Land Council, appearing for the petitioner association seeks permission to withdraw the petition, has filed this interim application for seeking permission to the liberty file a later one with detailed particulars. Prayer made in the interim application is accepted. Writ petition is disposed of, giving liberty to the petitioner. File writ petition of this. Yes.
Item 26.
Item 26, may I please, my lords? First, may I have IA number 573 of 2025, my lord.
What modification you want?
My lord, modification in order dated 6/1/2025, my lord. In IA 17355 of 2024. My lord, name of the petitioner.
कौन भूले कि कौन?
First petitioner का नाम है
कौन है?
देवाशीष नाइक होगा।
देवाशीष नाइक देव सेटा है। अच्छा। ଆଉ କଣ ଭୁଲେଇଛି କୁହନ୍ତୁ?
ଆଉ 5 ନମ୍ବର ପ୍ୟାରାଗ୍ରାଫ ରେ ଲାଷ୍ଟ ରେ 16/2/2022 ହେଇଯାଇଛି ସେଟା ହବ 16/3/2022।
ଦେଖନ୍ତୁ thorough modification. IN number 573 of 2025 is an application for modification of the order dated 6/1/2025 passed in IN number 17355 of 2024. Considering the government statement in the interim application and giving the current counsel for the respective party in the first title of the order dated 6/1/2025, the name of the petitioner which has been mentioned to be Sushant Puntia, the same shall be read as inverted Devashis Nair. And in column number paragraph number 5, the paragraph number 5, paragraph 3, fourth line. Paragraph 3 रे बोली
ना paragraph number 5 रो third line में
paragraph 5 paragraph number 5 third line where the date has been mentioned as 16/2/2022, the same shall be read as
16/3/2020.
16/3/2020. Best part of the past in the IN number 1 agreement.
Item 27.
Please, your lordship, on virtual mode.
Question number 2.
My lord,
Condonation of delay. Delay has only been condoned. Till today, appeal has not been admitted.
Just a minute.
permitted to make my submissions. I am a petitioner.
The IN number 569 of 2014 regarding condonation of delay, we have received notice and appeal.
May I be allowed to make my submissions? Condonation of delay has been already allowed.
27. IN number 1,444 of 23.
Another IN number.
How would I put
The appeal has to come for fresh addition. We have not received the copy of the petition because the petition was disposed of without issuing notice to us. The said order was challenged.
Read appeal or read petition original.
Therefore, unless and until the copy of the petition is sought, then we cannot take any step.
You are now appearing for the
Respondent number 2.
No, in this writ appeal,
Writ appeal notice has not gone. But the delay has been condoned.
Who has filed the writ appeal?
The employee has filed the writ appeal. I am for the management.
No, we are just one. Just please. Who is the counsel for this Vikari Charan Roy?
Mr. Senior Counsel is appearing on this.
I am appearing, my lord. I am appearing, my lord.
Okay.
I am appearing. I will be allowed to make two sentences, my lord. The delay is condoned, and my lord, notice has been issued. Notice has been issued, my lord. And secondly, I had taken an permission from the court on 22nd, 3rd, 2023 to the person aggrieved, or I am saying that the person is junior, to make him a party. I indulge your lordship's attention to the order dated 22nd, 22/3/2023.
Yes. So that is, you have stated that to include one Kumar Behera.
Yes, my lord. Therefore, I have filed an application to make him a party, and I have taken permission from the court in 22nd March 2022 to make him a party, because he may be aggrieved, he may be affected. Because I say that he is admittedly junior than me. Therefore, court allowed me to file an application. I have filed an interim application bearing number 144.444 of 2023. That may be allowed. He may be made as a party. Anyone interested to take any writ application, copy of writ application, I want to give them. But notice has been given. I feel, because lordship can look at the order dated 18/5/2022.
What is that IA?
I want to make someone as a party in person. Therefore, I have taken permission from the court.
Mr. Mishra,
Yes, yes, madam.
that IA which we are referring to, is it IA number 1444 of 23?
Bow down, not bow down, madam. Bow down.
You have prayed for the impletion of one person as respondent number 4, right?
Vijay Kumar Behera.
Or Behera.
And I have taken permission from the court to make him as a party.
Okay, so
That is dated 22nd 3/2023.
All right. Anyone has any objection to that? You have
Want to make someone as a party.
all right. So who is appearing for the chairman, Coal India, Mr. Patnaik?
Nobody is appearing, my lord. I am appearing with respondent number 2. One has notice has been got.
Just to council. In this case, you say that you are appearing for
Respondent number 2.
Chairman from Managing Director, Mahanadi Coalfield. And opposite party number 1 is respondent number 1 is Chairman Coal India. You are not appearing for that.
I am not appearing. Notice
Just a minute. General Manager so and so, that is also you are not appearing.
I will appear, my lord. If notice should go, I will appear.
My lord, Lordship, kindly consider the order dated 18/5/2022.
You see,
18/5/2022.
Writ appeal. Notices have been issued already. Okay. Now, during the pendency writ appeal, he has filed this interim application for addition of someone as respondent number 4. So again, notices cannot be issued. The already notice have been issued. The parties have already entered appearance. So no question of issuance of any fresh notice. So whether it is to be added or not, that is to be seen. So if you have no objection, let him be added as a party.
I have no
and
objection.
then he has, of course, notice to that fresh respondent, that is respondent number 4 will be issued, right? IN number 1444 of 2020 is an application for impleading one Vijay Kumar Behera as respondent number 4 in the writ appeal. No objection has been filed by any of the parties. Accordingly, the prayer made after going to this one, the prayer made in the interim application is allowed. Vijay Kumar Behera shall be added as respondent number 4 in this writ appeal. Consolidated first title be filed by the London Council for the appellant within a week, Mr.
Yes, ma'am, within a week.
After filing the also the requisite for issuance of notice on the respondent number 4 in this writ appeal. Matter will be listed after sworn.
I have clear my
Yeah.
The order arising out of the petition.
You want the copy of the writ petition? All right.
I will solve, man. I will solve it.
Take a copy of the writ
Let
petition.
him,
That is.
let him collect from my office, man. I humbly pray.
Number 11626 of 2014 on the London Council for the respondent number 2.
1, 2, 3. I will appear. 1, 2, 3. I have already appeared 2. Then 1, 2, 3.
Acha, the London Council submits for the opposite respondent number 2 submit that he has also instruction to appear for respondent number 1 and 3, and he will file his wakalatnama. And he submits that he has not received the copy of WPC number 11626 of 2014. Mr. Mishra and senior advocate submits that within a week we will serve a copy of the writ petition on the London Council for the respondent. Mr. Mishra, within 1 week you serve a copy.
May I pray one thing, my lord?
Yes.
Let him collect from my office because I have some personal problem.
The order will be this, but he will collect.
All right, my lord. All right, because I do not know the lawyer, therefore it may be difficult for me.
Okay.
I'll solve a copy.
We have live streaming copy.
Yes, sir. Not then money.
Supplemental list. Item number 1.
May I please your lordship, my lord? May I please your lordship, I am a virtual court Puri, my lord. I pray short adjournment so far 32 items is concerned, my lord. Process already completed, my lord. Shorted may kindly be given, my lord. Item 32, my lord. My lord.
So it is jail criminal appeal.
My lord, there is another appeal, my lord, 160 by 19. Tag both also. So I pray 160 by 19, my lord. CRL.
We are not passing it any order today. In that case, it will not be taken up for us today. All right.
Item number 5. I pray for time to receive all the depositions from the registry.
5, you wait when the matter reaches, make a mention. Yes, sir.
Item 1.
So, supplying paper, what is the order passed last time? 27/7/23 is the last one. So get ready, we are supplying the paper book just now. We are supplying you the paper book just now. Get ready for hearing next week.
Yes.
Okay.
Lordship, my name may be deleted. Se prisoner petition ta पक्षरे से पठाई दिले ओना रे सेटा तो कि
No. No, if the prisoner's petition is there, then you are to be given priority.
24/11 दिया है prisoner petition ता तो बनना 24/11 लॉर्डशिप
27/9 हाइपर लीगल सर्विस तापर 24/11
27/12 रे
नहीं 27/9
दिया है ताल तो prisoner petition should supersede.
24/11
That should supersede.
Prisoner petition ଟା କେତେ ଅଛି? Part C ରେ ବୋଧେ ଅଛି। ଏ prisoner petition ଅଛି 24/11/2023। ଆପଣଙ୍କୁ କେବେ ଏନଗେଜ କରାହେଲା?
27/9 27/7 ଥିଲା
27/9 ରେ ଦିଆ ହେଇଛି।
27/9/2023 ନା 24?
ନା 23
ଏଇ ଦିନ ଏଇଟା ପରେ ସିଏ କରିବେ ମ୍ୟାଡାମ କରିବେ।
You have filed your Vinama?
No, lordship. खाली prisoner petition से पठेइथिले ले मत फोन कर.
पटले जे वकालतनामा फाइल करना है.
Let's
You are the only Mandakini Panda in the. Yes. But there should be. Actually, prisoners petition sangere माने बेले वकालतनामा टा sign करी said पठी दिया. The moment counsel comes here, we just ask him to just put the signature. So
Friday रे फाइल कर देबी ता कहि छी फोन रे.
କହିଛନ୍ତି.
हां.
Then it's all right. We are just urging this case. You do the needful. Peruse the prisoner's petition at flag C, praying for engagement of Ms. Mandakini Panda in place of S.K. Gupta advocate. Ms. Panda submits that he has already talked to the appellant over phone and who is now in jail custody in Circle Jail Korapur, no? In Circle Jail Korapur. And she has been assured that the Wakalatnama would be sent within a week. The matter may be listed a week after. This matter will be commencing from 3rd of February 2025. No?
Lordship paper this.
आसी जाओ आपन वर्तमान आपन यदि वकालतनामा न देई परिबे then we may consider of giving it to also Mr. Mishra तेणु समस्त ना थाउ 3 तारीख आमे जस्ट रखुछु देखियो पे आपन ता भितरे जहा कथावार्ता करिया कथा कर दिनु है ना. Yeah.
Item 2.
Item 2, sir, that same appellant has filed another CR.
This criminal appeal will just share the. But I'm dispose of here.
Yes, ma'am. Right. Judgment dated 15/4/2024.
No, see judgment. Criminal appeal lo judgment.
Criminal
487 no judgment अच्छी देखी.
Yes, ma'am.
Date of hearing. Congratulations, we appeal has been allowed in part. Then let us see that whether it is same judgment or not. Ad hoc additional session judge, first track Chhatrapati. Sessions trial number 38 of 2008 bracket ST number 121 of 2008-GT60. Same. All right. Take down. JCRL number so on so. The registrar submitted a report that the appellant Mahantara Sethi filed criminal appeal number 487 of 2012 challenging the impugned judgment which has already been disposed of by judgment and order dated 15/4/2024. In view of such a report placed by the office notary as allowed, he mentioned the office notary. The office notary dispose of it in signature. এটা দিনেশ কুমার চৌধুরী মানে ওই যে বিলিং স্ট্যান্ডার্ড কি ডিসপোজ অফ কোটা এটা আছে যে ক্রিমিনাল অ্যাপিল জাজমেন্ট আছে দেখতে হলো এটা কেবে এটি 19/3/2024 জাজমেন্ট ଅଛି ନା ସାର୍ଙ୍କର ବାହାର କରିଦେବେ. ହଁ ଜଜମେଣ୍ଟ ବାହାର କରିଦେବେ. ସେଇଟା
तरह से ठीक
In view of such also, the
Yes,
clearly is disposed of. है ना?
Item 3.
Book date will receive.
No, what is your instruction, whether he has surrendered or not? So and so. Whether petition has a the report asking. है ना? कितने का लगे? 10,024 में मासिक additional session just shampoo. That reminder we sent the Lieutenant Court for complying the order dated 10/12/2024. Matter be placed on 27th recommencing from 27th January 2025.
Item 4.
Last occasion instruction was suffered from the statement. I was filed the application for plan number 3. On 31/7/2024, your lordship has allowed him then for a period of 1 month. And he has to surrender on time. Never violated any terms and conditions of the for instruction.
Against you.
Lordship allowed only me for 1 month. And in that 1 month, I have never violated Sunday. Usual report is being produced by the state always.
Usual means?
There may be differences between parties, there is group right.
No, they have collected the data. It's not that. They have collected the data and what you are also doing inside. So it is not that one and two, it's a entire Sahi people, family members of the deceased, and so it's not that.
There were all total 9 accused persons, and for 8 trial was commenced. In the meantime, 3 have been accused, and one absconded accused for whom split of trial is there. He has granted bail.
No, question is that you see the paper book is ready. So you make yourself ready for hearing. There are 4 appellants.
4 appellants.
And
1, 2, and 4 have been rejected.
4 appellants now, your lordship.
And see, each line of the report is each line.
My lord, and my lord, entire 3 brothers are inside custody more than last 11 years.
Doesn't matter. We have called for a report,
My lord.
and you see, at least we have to write something that what is your conduct. So call for a report, and if this is the report,
Conduct, my lord, in 1 month. In each and every time this honorable court has directed, I have appeared before the police station, my lord, and never made any disturbance.
No,
nothing, my lord, in the 1 month, nothing is against me, my lord.
This is the story of the police, my lord. You are asking, Lordship is asking, this type of report is being produced because there is the group rivalry in the Sai, my lord.
ସାଇଟା ପୁରା ଆପଣଙ୍କ ଏଗେନଷ୍ଟ
My lord,
ଗୋଟେ କେହି ଭଦ୍ର ଲୋକମାନେ ନାହାନ୍ତି ଯିଏ କି ଆପଣଙ୍କୁ ସପୋର୍ଟ କଲା ଭଳିଆ
because my lord, your lordship knows the police.
ପୋଲିସ କାହିଁକି ପଚାରିଲେ ସାହି ବାଲା ତାଙ୍କ ଫ୍ୟାମିଲି ମେମ୍ବର୍ସ ଆପଣ କଣ କଣ ସବୁ କରିଛନ୍ତି କଣ ଆସିଲେ କଣ ହବ everything they have collected and this is the report given ତେଣୁ ଏଇ circumstance you get ready for that hearing ଲେଖନ୍ତୁ IA number so and so this is an application for bail of appellant number 3 Devraj Behra alias Litu as per the order dated 12/12/2024 the Land Council for the state has produced the report of IIC Lalbagh Police Station for UPT dated 15/1/2025 wherein it is mentioned inter alia that there is anticipation of law and order situation pertaining to the safety and security of the family of the deceased. In view of such report furnished by the IAC, we are not inclined to release the petitioner on bail. Accordingly, IA stands rejected. However, since paper book has already been prepared, matter be added to the hearing list in the third week of February 2025. Third week ଗୋଟେ date ହେଲା 17 ତାରିଖ ଆସିବ ଆଉ କଣ get ready. Yes.
Item 5.
Yeah, Mr. Sorochandra Mahapatil and counsel for the informant is present for them. Yes, item 5.
Milord, in this case, I have not received the deposits from the registry. I need some time to receive and then.
What you are supposed to receive?
Yes.
କଣ?
By tomorrow.
କଣ ଚାହୁଁଛନ୍ତି?
Depositions, Milord.
Depositions. You have not received the paper book.
Paper book ପୁରା ହେଇଗଲାଣି ଆଉ deposition କଣ କରିବେ?
ନାଇଁ ମୁଁ paper book ବି ପାଇନି।
Paper book ଆସିବେ ନେବେ collect କରିନେବେ ଆଉ you have to collect it.
ଆଜ୍ଞା। By Friday ମୁଁ ନେଇଯିବି।
Mr. Pandal and counsel for the appellant submits that he has not yet received the paper book and he will collect it from the registry stock of this matter. So let it come on 27 and 27.
Yes, Milord.
1/2025. Yes, next.
Item 6.
Item number 6. Not I'm appearing. The prisoner petition has not come. The copy of the prisoner petition has marked to me present 43 minutes. On the basis of the prisoner petition, I am appearing now. Here the noting is not there, the prisoner petition has not come. But while sending the prisoner petition to the registry,
Copy has been sent to you.
Copy has been marked.
Yeah. The Land Council for the Mr. Biswajit Nayak Land Council has produced a copy of the prisoner's petition from Special Jail Superintendent Special Jail Raurkela, wherein a request has been made. Mr. Biswajit Nayak,
The original has come to me. And to settle the paper. 4 days. Copy the committee. Received a copy. After the algorithm is there since 2019.
copy does not forward.
It's a forward.
You were also there since beginning, 2019.
No, no, madam. First for myself, Virendra Kumar Mahapatra. My name may kindly be.
Oh. Madam, I filed my population in the 23.
Proud color. To engage him as the advocate for the appellant. The copy of the petition and wakalatnama has been forwarded to Mr. Nayak, and he has produced the same with us, which is taken on record. The wakalatnama filed by Mr. Nayak and his associates is accepted. The name of the earlier engaged counsel shall not be reflected in the cause history.
This is Nayak is there, so 17.
ମାନେ wakalatnama ତ ଫାଇଲି ଏଇଟା ନାହିଁ ବୋଲି wakalatnama ସେ ଫାଇଲି ଏଇଟା ଆସିବା କଥା କିନ୍ତୁ ସେଇଟା ସେଠିକି ଆସିନି ହଁ ସେଟା ଆସିନି ତାଙ୍କ ପାଖକୁ କିନ୍ତୁ ଗୋଟେ କପିଟେ ପଠେଇଛି ସେଟା ପ୍ରୋଡ୍ୟୁସ କରୁଛନ୍ତି so yes Mr. Nayak, so what do you say?
I did an application, two applications, an application for bail of the two accused persons and another is for reduction of fine.
2408 of 23 is for bail.
208 of 23 for bail.
How many months single appellant?
No, there are two appellants are
Two
there.
appellants.
Niranjan Ekka and Nilamani Lakra alias Negi Lakra.
Now you have never been released on bail earlier?
No, here actually order dated 21/6/2019 measure. Then Nilamani Lakra has released on bail for 3
weeks.
No. So interim bail for the marriage ceremony.
So that was a particular purpose.
Yes, sir.
Now, since when you are in custody?
The appellant number 1 is in custody since 21/9/2014.
21/9/2014. A1. And A2?
A2 millet since 23/9/2014.
23/9/2013. But excluding that interim bail period,
yes,
then it is almost comes to 10 years.
Yes.
So, is it a case under section? Conviction is?
Conviction is under section 302 against both the appellant and 302 and 307 against appellant number 2.
So, who is the injured come eyewitness?
That is PW 13 wife of the deceased. She is the only eyewitness to the appellant.
Deceased.
PW 13. Informant is not the
deceased.
No, sorry. She is the informant. Her name is Falguni. Falguni.
Falguni. And she is the wife of Manojika. Manojika the deceased in this case.
Deceased.
Okay, please place the evidence. Let us see.
I know the accused person. The occurrence took place 2 years ago at about 9 o'clock the night in our house. I was then cooking food. The accused persons came there, assaulted my husband with the iron rod on the leg and profuse bleeding from the head. They had also assaulted me other parts of his body. When I had tried to separate the accused persons, they also assaulted me with spray on my head. I fled to the house of Suraj and told him on the next day I had reported the matter to police. My husband died on the same spot of occurrence.
Who is the doctor who conducted PM?
Dr. TW 14 minutes. His whereabouts are not known. That is a minute. His report was PW 15 minutes. Dr. Basant Kumar Naik or Dr. Sanjay Kumar Titra.
PW 15 is the doctor.
PW 15 is the doctor who adduced evidence.
He is the medical officer, PDM.
Yes, ma'am.
On behalf of the doctor.
Was countersigned the postmortem.
All right. What you have seen?
Yes,
fractures. The right and left temporal bone, occipital bone, intracranial hemorrhage, subdural hemorrhage. Cause of death was due to vital organ like brain.
Exhibit 13 in the postmortem report. And also the doctor who who examined that lady, PW13,
No,
he has not been examined.
no. Who examined the wife, the wife of the deceased, is well at PW 10. Right. Nature of injury is simple in nature.
Anything you have brought out in the cross-examination of PW13?
Yes, ma'am.
What?
It was lordship similar. Although she is the informant Miller, but she has the police has recorded Miller. I am coming on the PW 13 deposition Miller, the last part. The chief Miller, then I will show you lordship the cross examination.
The matter to police.
Yes, ma'am. The report was scribed at our house at about 10-11 in the morning. I had also put some impression in my house. The contents of the same had been read about explained to me. Our local sarpanch had scribed the report. Then we had the next pillar. We had electric connection to our house. We had taken the food. We work in debris light, which is burning. The outside was dark. This line, they had already laid my husband on the ground before my arrival.
Laid her?
Yes, sir.
Okay.
Yes. She has not.
She was cooking food, no? Then
yes.
she
At the time of the I was present in the house. I had also been assisted in the court. In the same spot of occurrence, my husband also died. I am saying paragraph 4, running page 3. I met the police officer in my house. He examined me and the witnesses. Then the police officer required a written report and was submitted to the police. I had put LTA on the report and the inquest report. I do not know who scribed the affair. Being required by the police, I had put LTA on the report. Police had not examined me further. Then will you kindly come to the statement of the PW. Who is the scriber of this? Yes, my place. I do not know the informant. I know the deceased. I know the accused persons. They are the native of my village. About a year back, coming to know about the murder of Manojika, the local sarpanch, the village ward member, myself and other villagers went to the village, Chargudia Poda, to verify as to what has happened. There I found the dead body of Manojika lying in the inner courtyard of his house. Police was present there. On the request of the local ISI, I went to the local police station. On Bhagavan Kanta, PW3 of my village had accompanied me to the police station. Police asked me to submit a report and detected me once. I thereafter put my signature as the scribe thereof and handed over the same to the police. Exhibit 4 is the said report which I have scribed to the dictation of the IIC. Exhibit 4.1 is my signature. Exhibit 1/2 is my signature, which was obtained by the IIC at the police station. I have been examined in connection with the case. The village consists of 18 podas. The distance between my poda and that of the deceased about 5 kilometers. Exhibit 4 was scribed in absence of the wife of the deceased. Her LTA was not put over the same in my presence. The inquest over the dead body of the deceased was not in my presence. I have no direct knowledge. Here, he is not the sarpanch. The sarpanch has not been examined in this case.
Who are the two appellants in this case?
The two appellants, appellant number 1, Niranjan Eka, is the brother of the deceased.
Niranjan Lenka.
Yes.
Yes, I would appellant number 2.
Appellant number Nilamani Lakra alias Negi Lakra.
So both of them are related to the.
This is mine. Both of them are related.
So what is why the dispute was there?
Dispute is civil dispute.
Civil dispute. So you come to the FIR. Let us see that. The injuries as it appears are all on the occipital region. As per the evidence of that Dr. PW 15.
Yes.
The cause of death is also injury to the vital organ.
Yes.
FIR, please come to that FIR.
माने भारत मासे श्रीमती फाल्गुनी एका स्वामी मनोज एका अदर 19/9/2014 ରିଖ ଆପଣଙ୍କ ନିକଟରେ ଅଭିଯୋଗ କରିକି ଗତକାଲି 18/9/2000 ରିଖ ରାତି ସମୟ 9 ଘଣ୍ଟା ବେଳେ ମୁଁ ମୋ ସ୍ୱାମୀ ମନୋଜ ଏକା ଆମର ଛୁଆ ପିଲା ସହିତ ଆମ ଘରେ ଥିଲୁ। ଏହି ସମୟକୁ ମୋ ଦିଅର ନିରଞ୍ଜନ ଏକା ଓ ନାଗିଲ ଏକା ପିତା ଦ୍ୱିତୀୟ ଲେଖାର ଗ୍ରାମ ଆମ ଘରକୁ ଆସିଲେ ପ୍ରବଳ ପାଟିତୁଣ୍ଡ କରି ଝିଅର ନିରଞ୍ଜନ ଏକା ମୋର ସ୍ୱାମୀ ମନୋଜ ଏକାଙ୍କୁ ବାହାରକୁ ଆସ ବୋଲି ଡାକିଲା ଓ କହିଲା ମୁଁ ଫେରେ ସବୁ ଜମି ଯାଇ ମୁଁ ଫେରେ ସବୁ ଜମି ବାଡ଼ି ନେଇଯିବି ମୋର ସ୍ୱାମୀକୁ ଠେଲାପେଲା କଲା ଓ ମୋ ନିରଞ୍ଜନ ଏକା ମୋର ସ୍ୱାମୀ ସହିତ ଝଗଡ଼ାଝାଟି ହେଲେ। ସେଠାରେ ଥିବା ନେଗିଲ ଏକା ଓ ମୋ ଦିଅର ନିରଞ୍ଜନ ଏକା 2 ଜଣ ମିଶି ମୋର ସ୍ୱାମୀକୁ ଆକ୍ରମଣ କଲେ ଓ ମୋ ଦିଅର ନିରଞ୍ଜନ ଏକା ଧରିଥିବା ଗୋଟେ ଲୁହାର ରଡ୍ ସାହାଯ୍ୟରେ ମୋ ସ୍ୱାମୀକୁ ମୁଣ୍ଡ ଦେହରେ ପ୍ରବଳ ମାରିଲେ ଓ ନେଗିଲ ଏକା ମୋ ସ୍ୱାମୀ ମନୋଜ ଏକାକୁ ଧରିଥାଏ। ନିରଞ୍ଜନ ଏକା ମୋର ସ୍ୱାମୀକୁ ଲୁହା ରଡ୍ରେ ଚାବୁକରେ ବହୁତ ମାରିଥାଏ। ମୁଁ ଏହା ଦେଖି ନ ପାରିବାରୁ ମୋ ସ୍ୱାମୀକୁ ରକ୍ଷା କରିବା ପାଇଁ ଚେଷ୍ଟା କଲି, ମାତ୍ର ମୋ ସ୍ୱାମୀ ସତ କ୍ଷତବିକ୍ଷତ ହୋଇ ରକ୍ତ ଦ୍ୱାରା ବେହୋସ ହୋଇ ତଳେ ଘର ଅଗଣାରେ ପଡ଼ି ମରିଯାଇଥିଲା। ନେଗିଲ ଏକା ମୋ ମୁଣ୍ଡରେ ଓ ଦେହରେ ଗୋଟିଏ ବାଉଁଶ ଲାଠି ଦ୍ୱାରା ମୋତେ ଆକ୍ରମଣ କରି ମୁଣ୍ଡକୁ ଫଟେଇ ଦେଇଛି। ସେମାନେ ମୋତେ ଆକ୍ରମଣ କରି ହତ୍ୟା କରିବା ପାଇଁ ଉଦ୍ୟମ କରିଥିଲେ। ମୁଁ କୌଣସି ମତେ ନିଜକୁ ରକ୍ଷା କରି ଆମ ଗାଁର ଶ୍ରୀଦତ୍ତ ଗତିଆ ଘରକୁ ଗଲି ଏହି ଘଟଣା ବିଷୟରେ ଜଣେଇ।
No, the story in the FIR is that one was holding the deceased and this Niranjan assaulted on the head, right? And the head injury is the cause of death. But in the trial, they have changed, she has changed the version. As it seems, she stated that both the appellant came and assaulted my husband with iron rods on the leg and head, causing profuse bleeding with the head, and also assaulted on the other part of the body. If you will find in the FIR, there is nothing that this second man, Nilamani, was holding any weapon. Yes, that is not there. Has it been confronted that you have in the FIR you have stated like this? Because the role which has been attributed to A2 is that he caught hold of, and A1 assaulted on the head. Now in the trial they say that both of them assaulted by iron rod, not only to the leg but on the other part of the body. So certainly these two can not stand together so far as A2 is concerned. A2 was not holding any weapon as per the FIR score. But whether that has been confronted, no, should have been done in manner, because it was crime and he had just put the LTI, and it should have been also proved to the investigating officer, the person who registered the FIR, because it is not a written FIR by that lady. No. She has put the LTI only. Yes. So once you confront it, then it would have been proved through this one. So because it is not a substantive piece of evidence that we look into it, particularly when the LTA is given just.
That particular has not been confronted as the suitable packaging concern.
But you have remained in custody for 10 years, both of you.
More than 10.
What do you say, Mr. Hon'Ble? It appears that so far as A2 is concerned, you have changed the story, the trial. FIR version, अपन जहाँ पढ़िले, FIR कौन कहला? ये जो नीलमणि नारे कौन थिला? नीलमणि रोल टा कौन थिला कौन थी? FIR रे? नीलमणि पढ़िले परा आज्ञा? ସେ ପଢିଲା ବେଳେ ଅନ୍ୟ କଥା ଭାବୁଥିଲେ କି?
ନିରଞ୍ଜନ ଏକା ସ୍ୱାମୀକୁ ଆକ୍ରମଣ କଲେ ଓ ମୋ ଝିଅର ନିରଞ୍ଜନ ଏକା ଗୋଟେ ଲୁହାର ରଡ୍ ସାହାଯ୍ୟରେ ମୋ ସ୍ୱାମୀ ଓ ମୁଣ୍ଡ ଦେହରେ ପ୍ରବଳ ମାରିଲେ।
ସେ ନିରଞ୍ଜନ ତାପରେ ନୀଳମଣି ଦେଖନ୍ତୁ କଣ କଲା?
ନେରିଲାକ୍ରା ମୋ ମୁଣ୍ଡରେ ନୀଳି ମାନେ ନୀଳମଣି ସେଇ
ମୋର ସ୍ୱାମୀ ମନୋଜିତାକୁ ଧରିଥାଏ
ଦେହରେ ଗୋଟେ ବାଉଁଶ ଲାଠି ଦ୍ୱାରା ସେ ଆକ୍ରମଣ କରି କୋଉଟାକୁ ପଡୁଛନ୍ତି
ସେ ଲାଇନଟା ଛାଡ଼ିଦିଏ ସେ ଯୋଉଟା ମୋର ସ୍ୱାମୀ ଦେହ ମୁଣ୍ଡରେ ପ୍ରବଳ ମାରିଲେ ଓ ନେଟିଲାକ୍ରା ମୋର ସ୍ୱାମୀ ମନୋଜିତାକୁ ଧରିଥାଏ ଓ ନିରଞ୍ଜନ ଲେଖା ମୋର ସ୍ୱାମୀକୁ ଲୁହାର ଚାବୁରେ
ନିରଞ୍ଜନ ନାଁରେ ଆକ୍ଚୁଆଲି ଆଲିଗେସନ ଥିଲା ସିଏ ମାରଲା ବୋଲି ଇଏ ଥିଲା ଖାଲି ଧରିଛି ବୋଲି ଏଗୁଡାକୁ ଚେଞ୍ଜ କରିଦେଲେ ଇଏ ଭର୍ସନରେ ମାନେ ଟ୍ରାଏଲ କୋର୍ଟରେ ଅଲଗା ଦି ଜଣ ଯାକ ମାରଲେ ଆଇରନ ରଡରେ ଆପଣଙ୍କର ପ୍ରଥମ ଷ୍ଟୋରି ସେଟା ନଥିଲା 161 ବି ଦେଖିଦେଲେ ଥିବ ସେମ ଥିବ 161 ଟା ଦେଖିଦେଲା 161
person who investigate
या नाटा कौन PW13 ना
फगनी मतलब फाल्गुनी फगनी
हाँ अच्छी पेज नंबर 119 साल करो बात मोर दियर निरंजन इका धरिथिबा लुहार रड ताबली साहाय्य मोर स्वामी मुंड को देह को प्रबल मारले लेगी लाक्रा लेगी मीन्स जो नंबर 2 मोर स्वामी मजिका को धरी थाए निरंजन एका मोर स्वामी को लुहार ताबुले मारता मु यह देखी सही न परिवार मोर स्वामी को रक्षा करिया गला बेले मोर स्वामी को मुंडे सुआंश रक्त द्वारा बेहोश हो घर आगण पड़ जाते नेगी लाक्रा आपको मारला जोटा सिंपल इंजुरी दैट्स ए डिफरेंट मैटर तेणु 161 स्टेटमेंट ही भी सेया एफआईआर स्टोरी जहाँ 161 स्टेटमेंट सेया जे अपेलान नंबर 2 नीलमणि लेक्रा यार ना होची नेगी लेक्रा से खाली धरथला ये मारला जोटा कि ट्रायल रे देखिले अलगा टाइप रो कहनी कि से दी जन जाक मारले Heard the Land Council for the petitioner, Land Council for the state. Land Council for the petitioner submitted that the petitioner, one petitioner is in judicial custody since 21/9/2014. And we interim bail ki jaisra
appellant number 2
and so far as appellant number 2 is concerned he was taken into custody on 23/9/2014 but he was granted interim bail for a period of 3 weeks on the ground of
marriage ceremony of his daughter
marriage
no
can't be sister or daughter 27 years niece
the ground of marriage of his niece and after availing the same he surrendered at right time. Land Council submits that as such both the petitioners are in judicial custody for more than 10 years and in this case the wife of the deceased who has been examined as PW13 is the eyewitness to the occurrence and she is also an injured and she is the informant in the case and though in the first information reports also in the 161 CRPC statement she has attributed the overtact of assault on the head of the deceased only by appellant number 1 Niranjan Lekha and further stated that at the time of assault the appellant number Nilamani Lakra was holding the deceased Nahala Monojika but during course of trial he changed her version and stated that not only appellant number 1, but also appellant number 2 assaulted the deceased on different parts of the body, including the head, by therefore, as far as appellant number 2 is concerned, the person given during the trial stage is completely contradictory to that mentioned in the FIR as well as the 161 CRPC statement. He further stated that though PW 13 is an injured, but the doctor bracketed PW 10 has noticed one simple injury on his right frontal area. And the doctor who conducted postmortem examination was not examined, and the report has been proved by PW 15, the CDMO, Sundargarh. Sonpur. But ଏଠି ଲେଖା ହେଇଛି 19 ଶିବଥିଲା ସିଦ୍ଧୁ ପଚା
then
CMO Sonpur. So he further submit that there are good chances of success in the clips and balance of that is in favor of the petitioner. Therefore, the bail application may be favorably considered. Grand counsel for the state, on the other hand, posed the prayer for bail and submitted that the doctor has noticed fracture of right and left parietal bone, temporal bone, occipital bone, and there was intracranial hemorrhage and subdural hemorrhage, and the cause of death has been opined due to injury to the vital organ lies in brain. Considering the submission made by the Land Council for the respective parties, nature of the attack attributed against the appellant number 1, Niranjan Lenta, we are not inclined to release him on bail. However, so far as appellant number 2, Nilamani Lakra, alias Negi, is concerned, in view of the discrepancies as pointed out by the counsel for the appellant and his period of detention in judicial custody, and since there is no allegation of violation of the terms and condition of interim bail order, we are inclined to release him on bail allowed. Stay relation of fine also allowed. No?
Item 7.
Item 7 will IIC Rayagada student received.
Just a minute. What do you? What is his name? Mr. Kahar.
Sir, namaskar, sir.
You are discharging your duty as IIC Rayagada police station since when?
Since sir, 24.
to 24th February 2023, sir.
24 February
February.
23.
Yes, sir.
Okay. In the criminal appeal, we sought for some instruction to the Land and
Sir.
Council for the state, and he has also communicated with you, and twice he says that he has communicated with you, and you are not giving any response to him. So that is why we asked for your personal appearance and also for initiation of the contempt of court proceedings against you, because you are not obeying the court's order and not giving the necessary instruction to the state council, and thereby delaying the process of this court for consideration of the bail application. On by response করুন।
ସାର୍ ପ୍ରଥମତଃ ମୁଁ କ୍ଷମା ଚାହିଁବି ସାର୍ କୋର୍ଟ ପାଖରୁ। ସାର୍ ମୁଁ ଆଟେମ୍ପ ନେଇଥିଲି ସାର୍, ଯେହେତୁ ସେ ଯୋଉ ପ୍ୟାରେଣ୍ଟସ୍ ସାର୍ ସେଠି ଟୋଟାଲି ରେଣ୍ଟ ହାଉସରେ ରହୁଥିଲେ ସାର୍, ଆଉ ଯୋଉଠି ରେଣ୍ଟ ରହୁଥିଲେ ତାଙ୍କୁ ପଚାରିବାରୁ ସେମାନେ କେହି କିଛି କହିପାରିଲେନି ସାର୍ ତାଙ୍କ ବିଷୟରେ ସେମାନେ କୁଆଡେ ଗଲେ ବୋଲି। ଆଉ ତାଙ୍କର ଯୋଉ ନମ୍ବର ଗୁଡାକ ସାର୍ ଆମ ପାଖରେ ଆଭେଲେବୁଲ ଥିଲା, ଫୋନ ନମ୍ବର ଯୋଉଟା ସେମାନେ ଏଫଆଇଆର ଦେଇଥିଲେ ସାର୍, ସେଇଗୁଡାକ ସବୁ ସୁଇଚ୍ ଅଫ୍ ଥିଲା ସାର୍, ଆଉ କିଛି ମାନେ ଫ୍ରୁଟ ମିଳିନଥିଲା ସାର୍। ତାପରେ ପରବର୍ତ୍ତୀ ସମୟରେ ଆମେ ସାଇବର ସେଲକୁ ମଧ୍ୟ କଣ୍ଟାକ୍ଟ କରିକି ତାଙ୍କର ଅଲ୍ଟରନେଟିଭ ନମ୍ବର ବି କଲେକ୍ସନ କରାଯାଇଥିଲା ସାର୍, ଆଉ ସେଇ ନମ୍ବର ସବୁ କଲେକ୍ଟ କରିକି ମଧ୍ୟ କଣ୍ଟାକ୍ଟ କରିଥିଲୁ, କିନ୍ତୁ ସେଗୁଡାକ ମଧ୍ୟ ଇନଆକ୍ଟିଭ ଥିଲା ସାର୍। ଆଉ ଲୋକାଲିଟିରେ ମଧ୍ୟ ଯାହାକୁ ପଚାରିଲେ କେହି କିଛି ତାଙ୍କ ବିଷୟରେ କିଛି କେହି କହିପାରିନଥିଲେ ସାର୍, ତେଣୁକରି ମୁଁ ସାର୍ କରିପାରିନଥିଲି।
ତ ଏତେ ଜିନିଷ ଯଦି ଆପଣ କରୁଥିଲେ, ତାହେଲେ why didn't you intimate the London State Council that we are doing all these things, and in spite of all our efforts, we are not able to trace that victim boy, and therefore please ask for some time, more time. Why didn't you do that? Why you remain silent? If you are doing so many things after getting the order of this court through the state council,
Yes,
so
sir.
why you sat over the matter and did not communicate? ଯାହା ଆପଣଙ୍କର ସୁବିଧା ଅସୁବିଧା ଆପଣ ଜଣେଇବେ ନା ଚୁପଚାପ ବସିଯିବେ?
ନାଇଁ ଜଣେଇବି ସାର୍।
So
sir, today I have communicated this matter to
now
additional
କଣ ପାଇଲେ, କଣ instruction କିଛି ପାଇଲେ? What is your
ହଁ
instruction?
ସାର୍ ମୁଁ ଏଟା ଜଣେଇଥିଲି ସାର୍। ଆଉ ସାର୍ ମୁଁ ଜଣେ ତାଙ୍କର ଯିଏ ମସଜିଦର ଲିଡର ଅଛନ୍ତି ତାଙ୍କ ସହିତ କଣ୍ଟାକ୍ଟ କରିଥିଲି, ତ ତାଙ୍କ ଥ୍ରୋରୁ ମୁଁ ତାଙ୍କୁ କଣ୍ଟାକ୍ଟ କରିପାରିଲି ସାର୍। ଆଉ ବର୍ତ୍ତମାନ ସେମାନେ କସ୍ତୁରୀ ନଗର 5 ଲେନରେ ରହୁଛନ୍ତି ସାର୍, ସେଇ ଆଉ ସେ ଷ୍ଟୁଡେଣ୍ଟ ସାର୍ ବର୍ତ୍ତମାନ
ଷ୍ଟାଣ୍ଡାର୍ଡରେ ସେ ପଢୁଛି ବୋଲି ଲେଖିଛନ୍ତି?
ନାଇଁ ବର୍ତ୍ତମାନ ସାର୍ ସେ ପଢୁଛି 10th ଷ୍ଟାଣ୍ଡାର୍ଡରେ ପଢୁଛି ସାର୍।
କଣ ଲେଖିଛନ୍ତି? ବାସ୍ ତା ସ୍କୁଲ ନାଁ ବି ଲେଖିଛନ୍ତି
ସାର୍?
ଆପଣ ସ୍କୁଲ ନାଁ ବି ଲେଖିଛନ୍ତି, କୋଉ ସ୍କୁଲରେ ପଢୁଛି ଏବଂ ତା ସାଙ୍ଗରେ ଇଣ୍ଟରାକ୍ସନ ହେଇଛନ୍ତି ପିଲା ସାଙ୍ଗରେ?
Yes sir, 10th ଷ୍ଟାଣ୍ଡାର୍ଡରେ ପଢୁଛି ସାର୍, ପ୍ରସାଦ ଟେକ୍ନୋ ସ୍କୁଲରେ ପଢୁଛି। ଆଉ ବର୍ତ୍ତମାନ ସେ ଭଲ ଅଛି ସାର୍, ଆଉ କିନ୍ତୁ ତାଙ୍କୁ କହିଲେ ସେ ରିକଲ୍ କରିପାରୁଛି।
ଭୁଲିନି ବୋଲି ଲେଖିଛନ୍ତି।
Yes sir, ସେ ଭୁଲିନି ସାର୍, ସେ ମନେ ପକେଇ ପାରୁଛି ସାର୍।
Trauma or he's still in trauma?
Out of trauma. Out of the trauma.
Out of trauma.
10th ମାନେ ଏଇ ବର୍ଷ ମ୍ୟାଟ୍ରିକୁଲେସନ ପରୀକ୍ଷା ଦବ
ସାର୍?
ସେ ଥାଉ ଚାଲିଛି।
ପ୍ୟାରେଣ୍ଟସକୁ ସହିତ କଥାବାର୍ତ୍ତା ହେଇଥିଲି ସାର୍, ତ ସେମାନେ କିନ୍ତୁ ବେଲ ଆଉଟ୍ ହେବା ପାଇଁ ଚାହୁଁନାହାନ୍ତି।
Mr. Kamalakant Kahar, IAC, Rayagada Police Station, appeared to virtual as per the order dated so. He submits that matriculation ପରୀକ୍ଷା ଦେଖୁଛ ଯାଇ କୁଆଡେ କଣ ବୁଲିବେ ତା ସାମ୍ନାରେ? ନାଇଁ ନାଇଁ ଯେ ଦରକାର ନାହିଁ, ପ୍ରଧାନ ସେଇଠି submits that there was difficulty in tracing out the victim, for which
Personal dispense with it.
Item 8.
Item 8, my lord, your lordship has directed for the criminal antecedent. We have written letters on it, the antecedent to be obtained from state of Jharkhand, SP Humla district, my lord. As I am pursuing it, my lord, lordship may kindly allow one opportunity. I'll ensure that next date it will be there.
The land council for the state submitted that instruction has already been sought for as per the order dated 3/12/2024 by the SP Sundargarh from SP Humla district in the state of Jharkhand. However, some more time is required for obtaining the instruction. Put up this matter on such and such week for a proceeding.
Item 9.
As I have this matter earlier, that is relating to criminal offense 479 of 2024.
479.
Aye. In that case, madam, we both the accused are ladies and they were bail given trial. So 5 persons have been murdered.
They were on bail during trial.
Aye.
What is the role attributed to this lady?
Only witness is PW 13.
PW 13.
My lord.
He is an eyewitness to the offense.
He
was
expected to be
present.
the
Huh?
He was present at this spot.
Okay. So against these two ladies, this is item number CRLA number 479 of 2024. ଜଣଙ୍କ ନାଁ ହଉଛି କଣ ଅଙ୍ଗରା
Maji.
ଅଙ୍ଗରା ମାଝୀ ଆରଟା ନାଁ କଣ ପଙ୍କଜିନୀ ମାଝୀ तेरह नंबर साक्षी बाहर करें ट्रायल कोर्ट रिपोर्ट
I know the informant Kontura Thapa.
PW 13, yes. Varuna Thapa. Varuna Thapa.
Varuna Thapa in this case. I know all the accused persons standing in the dock. I know deceased person namely.
So on so
on 14/7/2013 at 7 a.m. the occurrence took place at Gocharal land of village Swanso. All the deceased had gone to Gocharal land to plow the land at the time I had been to that land to give tea. All the accused person shouted and assaulted all the accused person by means of badi, henga, tabali and tangia. They all dealt a blow of tabali, tangia to all the deceased person. When I tried to give them water, but all the accused person threatened me not to give water to them. All the accused person, all the deceased person died at the spot.
Allegation is in omnibus in nature.
Yes.
So, what are the total number of accused persons? This trial?
48.
20%. And what happened? All the persons were found guilty.
Yes.
Don't put your eyes on the
sound होची ना ताकि बघा. Anything you have brought out in the cross examination?
We do 13
So far, this yes, two ladies are concerned. Because the weapons, it starts from sharp cutting weapon is also there, and the hard and blunt weapon like badi, tenga, those are also there. Tangia. So
those were
Bibhinna.
recovered at the instance of accused Nilamaji.
So the doctor who has conducted postmortem examination is PW.
That is my lord.
Pillar 12. Pillar 12, Dr. Santosh Kumar Sahu.
He has conducted the PM of all the deceased.
PW 12 my lord.
हाँ 12 पूरा
Yes, yes.
नहीं ସମସ୍ତଙ୍କର ସେ କରିଛି ନା ଅଲଗା
ସମସ୍ତଙ୍କର ସେ କରୁଛନ୍ତି
no ତିନି ଜଣ ବୋଧେ କରିଛି
PW 11 and PW 12. 11 and 12.
Ramay Thapa,
Vishwajit Joshi.
Then out of the Madrasi Tapa. Paragraph number
that's
4.
Madrasi or Ramay? Out. How Ramel Ramel printer Ramel Madrasi.
PW 11 Kunu Thapa and Sadashiva Maji.
Home exploding brand.
କଣ ପାଇଁ ପାଞ୍ଚ ଜଣଙ୍କୁ ଇଏ କଲେ ଗୋଟେ ପରିବାର ନା କଣ
ଗୋଟେ ପରିବାରରେ
ପରିବାର ନୁହେଁ ଜଣେ ବାପା ଜଣେ ମାଝି
ଗୋଟେ
ଜମିବାଡି ଗଣ୍ଡଗୋଳରୁ ଆଜ୍ଞା ପିଟାପିଟି ହେଇଛନ୍ତି ଏମାନେ ବି ପିଟିଛନ୍ତି ସେମାନେ ବି ପିଟିଛନ୍ତି ଜମିବାଡି ଗଣ୍ଡଗୋଳରୁ ପିଟାପିଟି ହେଇଛନ୍ତି
ପିଟାପିଟି ମାନେ
ଏମାନଙ୍କର ଇଞ୍ଜୁରି ହେଇଛି କି
ନା ଏମାନେ ଆଉ ପୋଲିସ ପାଖକୁ ଯାଇନାହାନ୍ତି
ନାଇଁ ୟାଙ୍କର ଇଞ୍ଜୁରି ହେଇଛି and they have been admitted to the hospital also.
Have you laid any evidence to that effect?
Yes, man.
evidence ଦେଇ
ନାଇଁ ପୋଲିସ
କଣ
ଆମେ ପୋଲିସ ପାଖରେ
ଡିଫେନ୍ସ ଏଭିଡେନ୍ସ କଣ ଅଛି
डिफेंसिव ने बाकी टू डॉक्टर तो एग्जामिन ହେଇନି ବୋଧେ ଆପଣ ତରଫରୁ
ନା ନା କିଛି ଆମର କିଛି ହେଇନି
So number of injuries are also there. Indicates it's not a that one person or two person participated.
No, number of
because the manner in which PW12 ର ଦେଖିଲା ବେଳକୁ ମାନେ crossed injury, right leg, ମାନେ right foot hanging, ମାନେ ପୁରା एकदम ଚୋଟଟା ବସିଛି ଗଭୀର ତାପରେ ଅନ୍ୟ ଇନସାଇଜ wounds ଗୁଡାକ ଅଛି
20 ଜଣ ଆଜ୍ଞା ଟ୍ରାଏଲ ଫେସ୍ କରିଛନ୍ତି କିନ୍ତୁ ଚାର୍ଜସିଟେଡ୍ ଆକ୍ୟୁଜ ଅଲଗା ଜାଗାରେ ଆସୁଛନ୍ତି ଏଇ ଯୋଉ so far as those ladies are concerned and they have been after the incident they have been implicated
ଆପଣ ନା ନାହିଁ
PW7 ଯିଏ ଅଛି ସରୋଜିନୀ ଥାପା ସେ ବି କହୁଛି ଯେ ମୁଁ ସେ ସ୍ପଟ ଉପରେ ଥିଲି ସେ କହୁଛି ଯେ the women culprits were holding ଲାଠି and ଡକ୍ଟର କହୁଛି ଯେ ଲାଠି is not the ଡକ୍ଟର କହୁଛନ୍ତି
ଇନସାଇଜ ଡୋଣ୍ଟ ଅଛି ଲାଠି ଖାଲି
that's the PW12 କହିଲେ para 12 ରେ I cannot say which weapon can cause the which injuries specifically. It is a fact that the wooden lathis are not sharp cutting weapons. तापरे इन्स्पेक्टर जे अछि से कहउछन जे मु इंस्ट्रूमेंट गुडा पठेइनी फॉर द एग्जामिनेशन फिंगरप्रिंट पई पठेइनी
जस्ट को साखी कहले
PW7.
PW7 para 2 रे कहला
Just a minute.
कहले जे the women culprits were
PW7 is an eyewitness to the offense.
she is also claiming that I was there and all.
अच्छा कौन से देखिए accused persons are standing known to me. Occurrence took place so and so. All the disease started so and so. Hearing shouting from one, I rushed to the spot. My father-in-law so and so are dead. The accused persons armed with deadly weapon, tabli, axe, etc. While female culprits were iron rods and acha. Okay, just female money. Female hella iron rod and lathis. So you mean to say that there is no such injury which can be caused by iron rod or lathi? All the injuries are incised wound. That is your submission. Let us see once.
PW12, my lord. PW12, doctor is saying that I cannot say which weapons can cause which injury specifically. It is a fact that wooden lathis are not sharp cutting weapons. I also cannot say whether the lathi.
Which paragraph you are reading?
Para 12. Para 12 of PW12.
But what was your question? Was it specific or you have to, he has to say in each and every case? How can it be?
No, I am speaking with the lady. Actually, I am 384. There is 5 ladies are there. I am talking with the lady.
Just a minute. Let us be clear. So the doctor must have also examined the weapons, or it was not sent.
I have unless the query opinion.
No, my lord, para 18 of
the
that.
examination of my.
He is saying.
You see, come to para जो 12 number साक्षी रो जोड़ा PM doctor तार प्रथम injury टा देखो जाए. Cross injury देखिले. PM doctor first injury. PW12. Cross injury on left frontoparietal skull. এটা देखिले तो? हाँ? अपन पर डिपोजिशन कॉपी नहीं?
अच्छा.
PW12 रो एविडेंस देखिले? अच्छा. One प्रथम इंजुरी टा देखिले? I examined autopsy conducted over Ramel Thappa. प्रथम इंजुरी टा देखो. Cross injury on so and so. Hela? Now you come to the paragraph number next page. Paragraph 2, the second subparagraph. Injury number 1 is caused by hard and blunt object. Moderate to heavy weight forceful impact. बाकी 2, 3, 4 को होची शार्प कटिंग से कहउछन. तेणु गोटे इंजुरी सेटू बाहरुची कि अन्य सबुडा को अवश्य इनसाइज वुंड रहउची. से डिसीज रो
Kindly refer to page para 18.
Wait. अच्छा एटा गोटे देखंतु जोटा paragraph 7 रच से डॉक्टर PW12 रो. I have examined the weapon of offense sent to me on 6/11/23 at 12:15 PM. है ना? कौन गला जे ताबली गला लाठी गला सुआंसो तेणु तादेरु से मार्क कर दला आ जो 3 4 6 आउ 7 हला बांबू लाठी जोथरे ड्राइड ब्लड स्टेन रहउची. बाकी अन्य गुडा को होउची शार्प कटिंग वेपन को करे दला. है ना? वर्तमान ओपिनियन को पड़े आसंता परे. Injuries found on the dead body of the deceased can be possible by exhibit B1 to B5 and tabli A1 to A5. B1 to B5 को उड़ागो.
Cutting iron.
हाँ.
Lathi or so on. So handle of B1 to B5. अच्छा cutting edge of the roasted अच्छा सेटा. So tablet so on so. So that means he has not stated specifically that any of the injury which has been caused to any can be possible by this bambolati which he has marked as exhibit 3, 4, 6 ଆଉ 7 ଲେଖିନି ତଳେ ଯୋଉ 7 ନମ୍ବର ପାରାଗ୍ରାଫରେ ସେ ଗୋଟେ ଅନ୍ୟାନ୍ୟ ଜିନିଷକୁ ସବୁ ମାର୍କ କରିଦେଇଛି ବାମ୍ବୋଲାଠି ଗୁଡାକୁ ମାର୍କ କରିଛି 3, 4, 6 ଆଉ 7 ତେଣୁ ସେଇଟାକୁ ସେ କହୁଛି ଯେ ତା ଦ୍ୱାରା କୌଣସି ଇଞ୍ଜୁରି ହେବ ବୋଲି କହିନି ଇନଫ୍ୟାକ୍ଟ ଗୋଟିଏ ମାତ୍ର ଆଚ୍ଛା ହ୍ୱାଟ अबाउट 11 ଯୋଉ ଇଞ୍ଜୁରି ସବୁ ଇନସାଇଜ wound chop wound ଅଛି inside chop wound so Mr. Nayak ଆମେ ଯଦି ପାଞ୍ଚଟା ଯାକ ଡିସିଜ କୁ ଦେଖିବୁ ତାହେଲେ ପାଞ୍ଚଟା ଯାକ ଡିସିଜ ରୁ ଯାହା ଜଣା ପଡୁଛି ଗୋଟିଏ ଡିସିଜ ର ଗୋଟିଏ ଇଞ୍ଜୁରି ସେଇ ଗୋଟା ହିଁ ଇଞ୍ଜୁରି ହିଁ ଲାଠିରେ ପସିବଲ ଯୋଉଟା କହୁଛି ଆଉ ବାକି ଯେତିକ ଇଞ୍ଜୁରି ସେଗୁଡାକ ହଉଛି ସବୁ ସାର୍ପ କଟିଂ ୱେପନ ଏଇ ଯୋଉ ସ୍ତ୍ରୀ ଲୋକ ଗୁଡାକ ଥିଲେ ଆପଣ PW7 ଯୋଉ ଆଣିଛନ୍ତି ସେ ସ୍ତ୍ରୀ ଲୋକ ଗୁଡାକ ଆଇରନ୍ ରଡ୍ ଆଉ ଲାଠି ଧରିଛି which are obviously hard and blunt weapons ତେଣୁ ତାଙ୍କ ଦ୍ୱାରା ଯଦି ବି କୌଣସି ଇଞ୍ଜୁରି ହେଇଥିବ what is his submission that is the in respect of one disease that too on the head so far as the other injuries on the other disease because it is inside wound and chop wound the doctor has also stated that those are not possible ମାନେ indirectly se କହିଛି ଏଠି possible ଏଇ ହଉଛି ଯଦି ground ଥାଏ apart from ladies they were on bail during they were on bail so what is your submission
another ଅଛି ଗୋଟେ ଲେଡି ବ୍ଲାଇଣ୍ଡ
blind କିଏ ସେ
ସେଟା ଇନ୍ଦୁ petition number 4 in my 384
ହଁ
sir 384 ରେ 4 ନମ୍ବର
ନାଇଁ ଲେଡିଜ ଗୁଡା କୁହନ୍ତି ଲେଡିଜ ଏଥିରେ ଦିଟା ଅଛି ଆଉ କିଏ
384 my 384 ରେ all 5 384 ରେ all 5
384 ରେ all 5 अच्छा are ladies
all 5 are ladies
my ladies they are on
अच्छा they were on bail
ହଁ they were on bail
ଆଉ ଅନ୍ଧଟା କିଏ ତା ଯୋଉ
ଅନ୍ଧଟା ହଉଛି sir 4 ନମ୍ବର number 4 in that
ସେଇ 384 ରେ
ହଁ
blind ଆପଣ ରିପୋର୍ଟ ଆସିଥିଲା ପରା
yes ହଁ already 5
କାଇଁ
report last date ରେ your lordship already mentioned in the order I've got a mark 384 ରେ mention ଅଛି ଆଉ 479 ରେ ଗୋଟେ ରିପୋର୍ଟ ମଗା ହେଇଥିଲା ସେଥିପାଇଁ ପିଲାମାନେ କୋଉଠି ଅଛନ୍ତି ସେ ରିପୋର୍ଟ ମୁଁ ବର୍ତ୍ତମାନ ଦେଲି ଅଙ୍ଗରା ମାଝିର 6 ଜଣ ପିଲା ତାର ବଡ ଝିଅ
କାଇଁ ମୋ ସେ ରିପୋର୍ଟ କାଇଁ ଦେଇଥିଲେ
ହଁ
ଏ ରିପୋର୍ଟଟା ଦେଲେ
ଅନ୍ଧକା ଆଗରୁ ଅଲରେଡି ମେନସନ ଅଛି ଅର୍ଡର
କିଏ କୋଉ ଅର୍ଡର
384
18 12 24 ରେ मैं लिख लो appellant number 4 namely Indu Maji is physically 100% and also there is no record of criminal accidents against any of them.
So like that order. Take down this is criminal appeal number T84 of 2024 ଆଉ ଆରଟା ହଉଛି criminal appeal number 479 of 2024 ପ୍ରଥମେ ଆଗେ ବାହାର କରନ୍ତୁ 3 କାଇଁ ନା ଠିକ ଅଛି ଆପେଲ appeal ମେମୋଟା ଦେବେ ହଁ the appellants so and so have filed this application for bail. It is the contention of the learned counsel for the appellants that the appellants are ladies. They were on bail during trial. They have never misutilized the liberty. And the evidence of PW7 indicates
that the lady accused persons were holding iron rods and lathis, whereas out of 5 deceased in this case, only one deceased, the injury sustained by only one deceased, that is namely Ramel Thappa, is possible by such weapon, whereas the other injuries are either incised wound or chop wound, which can be possible by the sharp cutting weapon. And since the lady deceased persons, lady accused are not holding any sharp cutting weapon, the overtact attributed by the eyewitness PW13 in an omnibus manner that all the deceased also participated in the assault of the 5 deceased person appears to be suspicious, and therefore there are good chances of success in the appeal, and balance of convenience is in favor of the appellants. There is also no chance of early hearing, and therefore the bail application may be favorably considered. Learned counsel for the state placed the evidence of eyewitness PW13, PW7, so also
PW1,
the PW1, and the 2 doctors who conducted postmortem examination, that is PW11 and PW12. The submission made by the learned counsel for the acha au gote kon jo produce kartile report yaad re seta the learned counsel for the state has also produced the report from the jail superintendent, wherein it is mentioned that out of the 5 appellants, appellant number 4, Indu Maji, is physically 100% blind, and there is also no record of criminal antecedent against any of the appellants. Considering the submission made by the learned counsel for the petitioners and learned counsel for the state, and since the petitioners were on bail during trial, nature of overtact attributed against them, and since and the nature of injury sustained by the deceased person vis-a-vis the weapons alleged to be held by the appellants, and absence of any chance of early hearing of the appeal in the near future, we are inclined to release the petitioners on bail. बाकी next ଆସିଗଲା
PW1 ଜାଗାରେ PW5
5 acha say one ଟା କାଢି ଦେଇ PW5 କରି. Now you come to the other ଯୋଉଟା ରହିଲା criminal appeal number 478 of 20
479
479
ଆଜ୍ଞା
ହଁ 479 ତା ଦେହରେ 2 ଜଣ ଅଛନ୍ତି ସମାନ ରହିବ except ଖାଲି ରଖିବେ blind ଟାକୁ କାଟିଦେବେ ଆଉ ବାକି ସବୁ ସମାନ ରହିବ ହେଲା. So the jail applications are allowed, and stay realization of fine also allowed.
And much obliged. Your Lordship.
P84 ରେ ଆପଣ ଦେଇନାହାନ୍ତି କି stay realization of fine ଦେଇନାହାନ୍ତି କି? ଦେଇଥିଲେ order କାଇଁ ନାହିଁ application ନା order ହେଇଯାଇଛି?
ଅଛି ତ ମୋର ଆସିଯାଇଛି ଦେଖିଲେ ହଁ ହେଇଯାଇଛି ଏଇଟାର ଆଉ ସେକେଣ୍ଡରେ ଆଉ ଲେଖିବେନି ଏଇ ଯୋଉ CRL ନମ୍ବର 384 ରେ ଆଉ ଷ୍ଟେଜ ଇଲେକ୍ସନ ଅଫ ଖାଲି ବେଲଟା କିନ୍ତୁ whereas 479 ରେ ଦିଟା ଲେଖେ ବେଲ୍ ବି ଆଲାଉ କରିବ ଆଉ ଷ୍ଟେ ଅଫ ଟାଇମ୍
ଅନ୍ୟ କ୍ରିମିନାଲ ଅପିଲର ଫାଇଲ ହେଇଛି ସେଟା ଇଏ ଲକ୍ଷ୍ମୀ ଆର୍ଜେଣ୍ଟ
ଅନ୍ୟ ଗୁଡାକ ସେ ତ ଯେମିତି ଥାଉ ପଡିଥାଉ ନେକ୍ସଟ ୟେସ୍ ମ୍ୟାରେଡ୍ ଓକେ এইটা ଗୋଟେ କଣ ପ୍ରଡ୍ୟୁସ କରିଛନ୍ତି ওই ଯୋଉଟା ଦେଇଛି
ସେଇଟା
ହଁ ସେଇ ଯୋଉ ଆକାଉଣ୍ଟିଂ ଗୁଡାକ ଅଛି ତାକୁ ପୋର୍ଟ କରିଦେବେ ନହେଲେ ତାର ଯୋଉ ଯୋଉ ଆପେଲ ନମ୍ବର ଇଏ ଦେଖିଛନ୍ତି ସବମିଶନ ଗୁଡାକର ଆଡ କରିଦିଅ